can feel. My friend here, I have taken it.
42.
They have filed it yesterday, my lord. I have to leave for Delhi today, so whether I have requested for a subject here also on 10.
Lordship, it will not be agent on that.
No. We'll file our reply also.
Because
I
in
assure
case he's
you.
on interim bail and he's not coming.
Well, I assure my lordship that I'll do it on 10. They have filed.
He's not cooperating.
He's not cooperating.
But cooperating means what? I have seen only a few lines. I want to rebut those allegations. Your lordship will take it up on Thursday.
Now
next
see,
week.
there are, I also know that cooperation means what it means.
Yes, sir.
If a person can even remain silent also.
Yes.
But now what is the purpose of giving you a antecedent so that you can cooperate?
My lord,
If you complete your,
No,
your cooperation will be not there, then what is
No.
the use?
no, my lord, with
That,
utmost,
that is
yes,
maybe.
my lord, with utmost respect, my lord, what the CBI wants is that that I should give statement against myself.
No, that is not.
That's only. We'll clarify it, my lord, your lordship. I have requested my friend. We'll file a short reply. Let it be on record, my lord. Your lordship will take it up on Thursday next, my lord. Subject to your lordship's comment. And your lordship will make it clear that interim order will be till Thursday only.
No, that will do, but
And I know
maybe-
adjournment, your lordship can make it clear.
Okay, that.
Interim order till Thursday, no adjournment.
Interim
I'm a blessing.
content. Learned senior advocate, assisted by whom now?
I'm so monthly. I'll write down my
Name is dear, huh? I'm John. I don't know, is it a Borhava level? More grom legs. Who do you want? Okay, then, thank you.
We are blessing.
My lord, allow me to list, my lord, I mail application, my lord, for withdrawal, my lord. Today, my lord, at 2, my lord,
Today only.
at 2.
Okay, at 2.
Obliged.
May I please, item 41 anticipated bill, already my lord, the accused arrested, my lord, so my lord, it's infractious.
Already. CS also submitted. CS2 submit probably divorce. What is the CS number?
The charge number 22/2025, dated 31/3/2025.
282.
Already got arrested and become infractious. Okay, very
May I please, Your Lordship, I beg to mention item number 1 and 2, Lordship. Lordship, we are filing objection today. Lordship, this matter may be fixed at 2.
Yes, madam, I'm for the additional, madam.
You
We
have-
have filed additional affidavit, item number 1, madam. That may come on record, madam.
You have also filed additional
yes,
affidavit.
yes.
No, you want,
We are filing objection today.
acha.
This matter.
So matter would come different date only. Huh?
At 2, madam.
At 2.
At 2 will, you can, I mean, you're going to file the other side also.
They have already filed, they have to serve us, madam.
Okay, at 2.
At 2, madam. Obliged.
Hi, Your Lordship.
May I please, your lordship, lordship, I beg to mention for lordship, I have filed an IA for correction, lordship, can it be taken up to date, lordship? Only because of lordship, SDJM Vishwanath was given, but should be special judge Vishwanath, lordship, that much.
I did.
वहाँ पे correlation है। ठीक होगा?
I have filed additional affidavit today, madam. Kindly come.
Which case? Which number?
Item number 21.
Okay, we'll call it. Team item number 21. Affidavit.
Please, Your Lordship. Lordship, I beg to mention item number 22, Lordship.
Hmm.
Lordship, kindly pass over for the day, Lordship.
22, what about Borwa 22? It's a case of charge sheeted one or not yet charge sheeted? Scan copy along with the case diary. And case record also not received. Case record along with the case diary not received. Issue reminder, registry will do the needful. List accordingly after Bihu. After Bihu.
Yes, my lord. My lord, I beg to mention item number 40. For adjournment, my lord. Take maybe 11 my lord, 11.
Item number 40.
40.
Ah. Yes, 11th April. We are not fixing any date on 11th.
It will be fixed by
11th April.
11.
No, we are not fixing
Then-
11.
Then, my lord, after reopen 22, my lord, 22 April.
You're going to retain then? Okay, 22 corridor. Case the CDB retain till next chapter.
Wait, please, effective mention item number 32, my lord. Kindly adjourn for the day, my lord.
32.
32. Taken
It
up-
will be after B only.
Okay.
Okay. 32 we have received the case diary. Oh, sorry, records are there now. Is it charge sheet
Charge sheet, okay.
after B?
This one.
May it please your lordship. Lordship, I beg to mention item number 19 and 20. Lordship, we file for an additional affidavit. Lordship, the same may be called.
19 and 20.
Yes, sir.
Back to mention item number 13 and 17, 1, 3 and 1, 7.
Hmm.
So matter may be H1 for the day lordship. Lordship, can it be fixed somewhere in the next week?
No, not
Ah.
at all possible.
Lordship, 24th of April.
24th, we have lots of cases, I think in 24, maybe on 25th. Both the matters?
25th and 26th would be good. Both the matters together, 25 and 26.
One should be 25 and one answer. Okay, then item number 13, we are fixing 26 is a holiday. 26 is a holiday.
27 and 28.
Okay, after Bihu, it will come now. After Bihu, okay, after Bihu.
After we.
Here, what is the position? Scan copy record is now. Okay. And these are all after Bihu, no? Yes,
I will mention item number 6 for withdrawal.
6.
6. It is infrastructure.
Matter is already in fractures. Your good name?
RL Sutia. 6.
He got arrested.
No, Lordship is already another affairs, another bail application is filed. Lordship.
Achha. As per instruction, you want to withdraw. Need to withdraw. Yeah. Okay,
Please, Lordship. Lordship, I beg to mention item number 10. Lordship. The
10.
English- Yes, Lordship. The English conduct council is, Mr. S. Das is out of station due to something like. So kindly. matter may
Engaged
be-
council is out of station. Other side is SC and CB, na?
Kindly fix another date.
It will be after BU vacation. So why with the consent point over there? At the request point.
Yeah, please, your lordship. I beg to mention item number 30 in the daily list. Perhaps not
30 or 13? 30.
38.
38.
Yes, sir. Perhaps my indicated was Sashit file. I'm on interim. Lordship.
Yes, CS number?
CS number, my lord, 49/2025,
Hmm.
dated 25/3/2025.
Oh, you are on interim. Interim be extended. We are interim, we are going to extend up to 15 days.
Deeply obliged.
Yes.
So they were arrested on 26th of February, madam. But you will find the FIR at page 8. FIR has been registered under POCSO section 12 and 21 is there. And also, my lord, previous injury is there, my lord. Relevant page, also will find at page 12. FIR. In a rehab center, my lord, these two accused persons who were all patients, they tortured the victim boy also, which is stick, my lord. Later on, the mother filed a complaint that his son, who was a patient in the rehab center, were tortured. That's couple, my lord, this law should be moved because during the consent. And then that's how, my lord, also has also been included, section 12. Section 12, my lord, the punishment, maximum punishment is 3 years. There is no intention as such. And my lord, regarding this injury, I have enclosed the medical report also, my lord. Doctor says there is no injury. So my lord, my submission will be my lord, section 117 and 11 will not be attracted, my lord, in this case.
Yes, Borva.
My lord, one more thing, my lord.
Hmm.
My lord, though my lord, use of a steel stick has been mentioned in the FIR, my lord. But police has seized nothing, my lord. Only Shizira list I have enclosed, my lord, page 21. Page 21 or let's you can see. One plastic pipe of length 2 feet. That was only seized. Because this is the rehab center, my lord. There is nothing but. Another one, there is there that is case 23. This is mobile license. And medical report lordship will find at page 18. Page 18 is the medical report. Kindly turn to page 19, my lord. Opinions head for. Number 3.1. Boys are also all are 26 to 28 years old, madam. They are behind bars since last 36 days.
Not possible, my lord. To a certain whether I'm going to POXO attacks or not, my lord. So, madam, let the notice be so that, my lord, that may be fixed, my lord.
In that case, my lord, I'll be praying it let it be before due vacation, my lord, because already they are 36 days behind the bar, my lord. It can be done, my lord. If it is on 10th, my lord, Thursday.
Now you are all insisting before Bihu. We have no dates, in fact. If you go by the record, already fixed matters are 2025, or fixed matters are there, therefore motion matters will be there. It will reach. You are trying is different thing. We have to try now. Insisting on before Bihu. What? How can we? It is possible. Reach কইলে করব আস্তে আস্তে গুছি গলে হলো issue notice today you take tips.
I'll take it.
Issue notice ke simple কই দেব কোন দেখিও না লাগে issue notice to respond number 2 hard করব respond number 2 দিতে পারবেন কি section মিলাই গেলে শর্ট কই দেব simple করিব issue notice to the respond number 2 to register police station related to the office of register public আর এগুলো লিখো না লাগে case under simple করে দিব
Public.
বিহুর আগত লাগে পাগল করে দিব এটা
It's a similar rare file of in this case also. At page number 17, my lordship will find the FIR.
Case number 17.
17, my lordship operated for us.
This is to 6 POXO.
This my lordship case is on second FIR. Actually, in 2023 already.
No, whatever, 6 POXO is there. So we have to issue notice to the respond number 2, and we also calling for a case diary. That part.
Right.
So,
This full my lordship.
no, we don't have any dates. How many since when he is in custody?
This is since 14th. 14th of last month.
14-3. It's a 90 days offense otherwise also.
My lordship.
Later after B.
Almost like may I pray one thing, my lordship. In this case, if my lordship will see at paragraph number 6 of my petition, in February PS case number in 2023, already this FIR was lost. That case has already been charged.
Well, in that case, at the time of hearing, bring all these things, but
Yes,
at
I have
present, we are
already
not in a position to hear the
mentioned
matter
that also,
in
my
absence.
lordship. So wait on a 10th, my lordship.
No, sorry, not at all possible. It will be 24, 24, 24. Simple করে issue notice আমি পাস করে This is a case under section এগুলা করে দিব simple করে দিব মোর লাম্বা হয়ে গেছে না
Made
Yes.
the lordship.
Yes.
That crypto app, my lord, your lordship, is just the same FIR, my lord.
On the case number different, my same content, your worship, for the other day after, day before yesterday, my lord.
So crypto,
That I am giving us your worship for the same, my
when
lord.
it was fixed, other one.
No, other one already your worship disposed, my lord. That is 47, 48 on that, your worship. I have annexed also, my lord, I have given the original copy, and your worship's order is okay. Same contents, and I have given a copy to my learned friend also, my lord. Same content, same only case number is different, my lord. Everything is same.
Here also 47 is not there.
No. Same content, everything is same. Content same, everything is same. So on the date of election here, I'm at 325. And that's a different file.
This is which pane it is written as 47. Again, next page also 47.
You are 3%. 3% now. 70%.
No, notice was blank or what? No section was mentioned earlier. So definitely. You have put the 47 there,
Page 22, my lord, your worship.
22,
Page 22.
22.
Yes. Page 22, your lord. Notice, your lord, 47 is written now. That is your case number same, my lord, case number same, person same. my lord.
So in for page number 22, you have annexed only one notice,
And page 24.
22, 24.
24 second notice, 3 persons are there.
122, then 24.
24 and 26. And original I have given to your worship.
These are 47 and 48.
48 not given, my lord. We have stated now.
48 not issued
Not issued. Same thing, RDF is also same thing.
out of same FIR.
Same, not same FIR. FIR different, only my lord, number is. Which number is 130, that was 31, which I.
The contents of the FIR is there.
Everything same, everything same. Keep going. This is 30, that was 31. Same contents.
Yes, Borwa.
This is my lord 31, so lots of things granted bail, my lord. And this is my lord 30.
This is 32.
30 of 2025.
This is 30.
And my lord, sections are my lord.
Same. Same section. Possible.
Sections are my lord, in this case, my lord 61 to 3182. Then my lord 3182, then 3184, 3082, 111 of BNL. So it was section 66D of IT Act.
So,
In this one, present one,
Present one, my lord.
and earlier one, so
earlier one also.
same page number.
Other case, my lordship passed the order after perusing the case.
No. Motion.
Case that was
No.
At the stage of motion stage itself. I think. Okay, that will pass the order. Yes, Borwa same out of same. But I mean, same contents of the FIR are same, I think.
Yes, but same.
Okay. Yes, obvious. Obvious.
Obliged to.
কিন্তু ইয়াতে already আছে তারপর চাই পেলাই খালি লিখি দিলে
On the date of on the arrest is different. Arrest is same.
order হবো dispose করে দিই
44 of the supplementary list.
Make the general is 70-year-old man, is the handlebar for the last 38 years and was the president of Helen Gao Bonsai Lordship, FIR is page 18 Lordship. Page 18.
yes
Respect, I beg to state that on 24/2/2025 at around 3:30 PM, my daughter, namely Dia Baby, came to me crying and reported that she had gone to the house of the petitioner to look for gooseberries. However, the petitioner lured her inside his house under the pretense of giving her gooseberries. And once she went inside, he forcefully pressed her face with a pillow and attempted to touch her private part with a wrongful intent. At this moment, one Durga Bustula, a friend of her daughter, who was also looking for gooseberries, called out by her name, and upon hearing this, petitioner released her daughter, but before letting her go, threatened her that if she revealed the incident to anyone, he would kill her. Lordship. 38 is already behind the bar.
No, whatever, it's a POXO.
Okay.
You have to issue notice.
Lordship.
Okay, issue notice. He is behind the bus since last 38.
Last 38 days, Lordship. And that may be before vacation.
Before vacation, we don't have.
Then on 22, Lordship. Or 24, Lordship. 24 April. Lordship.
22, 24, 22 করা ভালো লাগে।
24,
Final
Lordship.
class, 24. ওই তো আর কি করবো এটা উপায় নাকি হলো স্যার। Okay, then 24. Yes, you take steps today about tomorrow by tomorrow.
Apply it. CD may be called for that.
Yes, yes, obviously we are calling sir. CDP call for issue notice. 24/4.
45. May I please the lordship, matter may be passed over after something, your lordship. Apply,
Oh.
your lordship. 46.
Item number? Item number 20. Okay.
47.
May it please your Lordship. Lordship, Sarshitan matter, Lordship. Case record may be called for, Lord.
Item number 47.
47, Lordship.
Charge sheeted case, na? Is
Lordship.
that POXO or NDPS?
Lordship, Poxlo.
Scan copy, simple code, scan copy of the case record along with the case diary be called for. Registry will do the needful. List accordingly. After Bihu will do, after Bihu petition. If you insist on that, then it will be
Any
update-
date, Lordship, 28 or 30, Lordship. Otherwise, it will not.
30, 30.
30, Lordship. Oblige your Lordship.
ইনার কোভিড প্রবলেম হয়ে আছে কিনা মানে কি হয় কি ইনার কোভিড কেস সাইন লিস্ট হলে না লিস্ট সাইন হলে এবার ইনার ডেট কি বলো লিস্ট অনলি অন দ্য দুটো দুই তিনটা কোড হবে তিনটা কোড চাইবে আসলে কি হচ্ছে
97.
May it please your Lordship.
Yes.
Lordship, this is a 482 application, Lordship. FR is on page 8, Lordship.
Yes.
If I may read the FIR, Lordship. Lordship, I humbly submit this complaint that at our house located in Patharghat Ward number 2, we store goods for our shop and neighbors also reside there. Today on the morning of 16/2/2025 at approximately 4:30 am, the below mentioned accused along with 10-15 unknown individuals forcefully entered our premises by breaking the lock of our gate. Upon entering, they snatched the mobile phones of our laborers, number 1 and number 2. After snatching their phones, they started assaulting them. Hearing their cries for help, people from the neighborhood gathered and the accused fled the scene. In the haste, they left behind 2 mobile phones and 2 motorcycles at the incident location. Upon reaching the scene, we witnessed the situation firsthand. Now, Lordship, this premises, Lordship, has been illegally occupied by the said complainant, Lordship. Lordship, we have annexed, that is the sale deed that is on page 19. The land belongs to one Noreshwar Bosumatari, Lordship. This is the deed of sale of 23rd June 2009, Lordship.
In whose favor?
Lordship,
In whose favor?
Lordship, ownership is Nareshwar Basumatari. This is the real owner. His land has been illegally occupied by the complainants. Now, these people, Lordship, his land, they don't know they have occupied this land. And now, when they went to their land, Lordship, these people started assaulting them and started misbehaving with them. That is the problem, Lordship. This real owner is someone different. Someone is illegally occupying, Lordship, and then they are filing this FIR against the people, Lordship.
Well,
The owner-
why you are not the owner?
No, I am
Yes.
with the owner, Lordship. I am with this owner, Lordship. This owner has actually gifted this said land, Lordship. That is on Annexure 2, which is gift deed, Lordship. That is on page 13, Lordship. That is on 18(1). He has gifted this land to the president of Hindu Yuva Parishad, Lordship. That is Navakumar Brahma, Lordship. I have annexed, Lordship. Page 17 is the real one, and the typed copy is on page 13, Lordship. Annexure 2.
But the name of the informant, what is his name?
The name of the informant is
Sanjan.
Lordship- yes, Sanjan Paul.
Sanjan Paul.
No, yes.
Sanjan Paul, how related?
Sanjan Paul has illegally occupied that land, Lordship. That land, that who is the original owner. Now they have gone there, and then they started doing all this rakas, Lordship, and thereafter they have
And the name of the accused is one Ranjunath.
yes, Ranjunath. Ranjunath is alongside. He is the secretary of that secretary. That president is this person, Lordship.
Navakumar.
Yes, Lordship. All the sections that have been added, Lordship, they are all,
So you have filed this petition for Ranju.
yes, only Ranjunath. Only Ranju Kumar.
So why Ranju was there?
Lordship, actually,
He
that-
went with this Nabo.
yes, Lordship, Nava Kumar Brahma. He went there, Lordship. Thereafter, Lordship, they started rakas, Lordship. Thereafter, his phone fell there, and then they filed an FIR against him.
Yes, Bora.
My lord, two mobile phone, my lord, they taken away two mobile phone, my lord, and also assaulted, my lord. The, my lord, labor person. Now, my lord, is Ranju Nath, my lord, he is no way related to the land in question, my lord.
Yes,
So in this case, my lord, there is a case that will be confirmation.
kindly some internet protection. Maybe.
So why Ranjunath is not related? Why he went there?
Ranjunath, Lordship, if I may, Lordship, Ranjunath is the secretary of Hindu Yuva Parishad, Lordship. Navakumar Brahma is the president, Lordship. They had gone there because this land was gifted to Hindu Yuva Parishad, Lordship. They had
Land
gone there.
gifted to Navakumar Brahma.
Yes, he is the president of Hindu Yuva Parishad. If Lordship on Annexure 2, that is the gift deed, Lordship may
Let the
come.
case that be called from, my lord, it will be clear.
Lordship, all the sections that have been added, they are all not very serious sections. So, Lordship, kindly interim may be granted at this time. Everything will be clear, Lordship. If
You are Mr. M.
Mr. P.K. Dar.
And also had Mr. R.J. Bora, so and so. This is an application under section so and so. Mr. Das, will learned additional learned counsel for the petition submitted in this regard that the present petitioner is no way involved in the alleged offense. However, it is a fact that he, along with some members of Hindu Yuva Parishad, visited to the place of incidents as it was illegally occupied by the informant. On that, there was a quarrel, and apart from that, no other incident had taken place as alleged in the FIR. However, the present petitioner is ready and willing to cooperate the IO in further investigation of this case if he is granted with an interim protection. Next, para Mr. Borwa, the learned additional PP submitted in this regard that city may be called for to know the actual fact of the case. And order of bail may be passed accordingly on perusal of the case diary. Again, interim DD protection. Okay, you'll be under interim protection. Yes, Borwa, when you
CD,
can
my lord, 5, my lord.
5. Appear before the IO, cooperate in the investigation.
Deeply of it.
8 to 9.
Lordship, case diary may be called for, Lordship. And in item number 9, Lordship, that grounds of arrest were not communicated, that ground is there. So first, Lordship may call for the case diary in item number 8, Lordship.
Item number 8 of this diary call for you. Yes, Borwa, when it can be fixed?
My lord, coding one CS, my lord. So, my lord, that will be after vacation only.
Pardon?
After vacation, my lord.
Oh, you want
29,
29.
29, 4, my lord.
And in 9, you have taken another plea.
22.
In item number 9.
Yeah, yes, item number 9. Additional affidavit is there. Page 22. This is Lordship, written as arrest memo under section 36. So probably it is the document which was prepared at the time of arrest, not under the notice under section 47 or 48. But we have applied for that, but only this documents was given. So if my learned friend can bring it from the IO, only that this document and submit if grounds are there or not. Only that much information if we can get. In a
Yes,
short day.
Borwa, when it can be.
Item number 9.
Or why don't you apply for any certificate copy?
We
You
have
can, you
applied,
can.
only this document was given, therefore I am pointing out before your lordship. In the application which we have filed, we have given section 47, 48, any notice, only this notice is given. So you will verify lordship if any grounds are communicated, you will put this.
Yes, my lord, then 7, my lord.
7 for idiot. The learned additional PP will, you'll bring the now this entire case diary you want to bring?
My lord, and to ask my lord, how the particular of this, my lord.
Case diary and the additional PP will also make an inquiry regarding the service of notice under section 47/48 BNSS. Okay.
All right.
We're hearing item 11.
Item.
Case report not received. Case report not received, Lordship.
It's not received. Oh. It will be required, I think, if case record is not received.
Last date, actually, I just missed this code by 2
On
items.
the none, on last occasion, you are not.
7 was the item number. I just ran and came and it was 29 at that time.
Oh,
So my lord, my lordship, as per your the court, whatever it says, but he is in jail for something around 294 days. On 4 days of this is he was in Agartala jail also. And this honorable court has granted a 12 days interim this one for this because his father has
Expired.
committed also. His father actually committed suicide. He was in police department actually. So this matter may be treated as per the court's one. Or if the court wants me to argue the matter, I am ready for it. So if the
No,
court-
without case record, most probably they may not be in a position to argue the matter.
as per
Because
the-
there are some materials, and have you filed any objection here? But for objection, we cannot, we can call for the case record on the next day, hearing has to be there. You may peruse the case record and verbal oral submission will also do. Okay. When new Kalatama was filed by you or what?
Yes, it is to me. IS Majumdar.
Ah.
And I could ask for a short date, but I have heard that this court is totally full with the
Yes.
cases, so I would not press so much as per the court's wishes.
Scan copy of it has not been received by the registry. So as per office note dated 29/3/2025, the scan copy of the trial court record has not been received. Registry is hereby directed to issue reminder to asking the learned trial court below to furnish the scanned copy of the case record along with the case diary on or before the next date of listing without fail. In the meantime, the respondent side is at liberty to file their written objection, if any. List accordingly when it can be listed because person is in jail. 29 will,
29th of, I'm sorry.
April, it will be on April
29th of April, yes.
29th.
Of course.
Nice. Hard sorry, would it one like short. No cost stories. Yes, 12.
My lord, in this case, I am behind the bar for last 1 year, 8 months, 19 days, my lord.
1 year,
8 months, 19 days, my lord.
Hmm.
It is 628 days as on today.
1 year, 8 months.
8 months and 19 days, my lord.
Hmm.
Here, my lord, allegation is that from 4 persons, my lord, 25 kgs of 25 kg plus ganjas were recovered. And they were, my lord, then taken into custody. And thereafter, my lord, the charge sheet was laid in this case, citing as many as 8 witnesses to prove the case, my lord.
How many? 8.
8 witnesses, my lord. Lordship will find the charge sheet is laid, my lord, on 2023, my lord.
Till now, is there any witnesses?
Yes, my lord. I have till my filing of the bail application, 3 witnesses were examined and cross-examined, my lord. And thereafter, only PW4 was partly examined as MR was not available, my lord. So examination of and further examination could not take place, my lord, till date. And my lord, thereafter, my lord, my first round in this case is that, my lord, I have marked the same trial court's record, my lord. If I may allow to be place this on a certified copy, my lord.
Yes.
It's green color flag, my lord, that info notice under section 50, my lord. Admittedly, there was no ground, only an information was shared with the petitioner, my lord.
This is 50.
Yes, yes, my lord, 50. So, Lordship will find, my lord, only information was shared with the issued with the petitioner stating that he has been arrested and he has a right to move the court for bail, my lord. That much information was shared, no grounds of arrest, nothing, my lord. And second page is arrest memo is also there. There also Lordship will not find any grounds as to why he has been taken.
Which one then?
Arrest memo, my lord. That second page, Lordship has got it. Certified copy I have provided, my lord. It is also in the records.
Yes.
Lordship, in the 50 notice as well as the memo, my lord, there is not a single whisper regarding the reason of grounds of arrest, my lord. So that is one of the crux of the issue, my lord, for arguing before the Lordship for consideration of my bail application. Further, my lord, just my lord, on the point of prolonged incarceration, my lord, and just this small three judgments of Honorable Apex Court. This was preferred. These were all from our High Court rejected, my lord, and Honorable Supreme Court was pleased to grant, my lord. That first order, my lord, here in this case, there are 5 witnesses, my lord, to be examined by the prosecution. This is also under my lord, special act, narcotic NDPS act, my lord. And out of 5, only 3 were examined. So, considering the incarceration of 1 year, 6 months, my lord, this specifically there, the Honorable Apex Court was pleased to grant bail to the petitioner, my lord. And my lord, the second one is Lordship has earlier also gone through, my lord, Vishwajit Malal, he is also in custody for, he was also in custody for 1.5 years, Malal. He was also Malal granted bail by the Apex Court, considering this long incarceration as well as no criminal antecedent, Malal. And third one also, Malal, that Virendra Kumar Chaudhary Lordship has got it. Lordship had got it third one, Malal. They are the second line. There only this petitioner was in custody for 17 months, my lord. And considering the right to speedy trial, the Honorable Apex Court was pleased to grant them bail, my lord. So, my lord, my humble prayer before your lordship to consider, my lord, the violation of the mandatory provisions of CRPC as well as the constitutional mandate and the prolonged incarceration, my lord. And I further undertake to, my lord, appear before the trial court in the event lordship, my lord, considers my prayer. And I'm ready to furnish, my lord, any surety as provided as pleased by this honorable court. my lord.
Here, the bill is actually 724. All places were 11 out of 8. That means the trial is progressing in a very good pace, my lord. And my lord, in utmost respect, my lord, the Supreme Court has never said that this is the period you should consider the minimum period or maximum period. Because it will depend upon the cases to cases, my lord. There are cases from here also and from your lordship's own judgment, from it remark. And there are, my lord, because this point arose from the case of my lord and Muhammad Muslim, my lord. And that there, my lord, in 7 years, only 5 witnesses were examined and other lot of witnesses yet to be examined. Because in all those cases, the point was detailed trial, but there is no here going by the record, there is possibility of completing the trial in a short time. Because already one is examined in 11,024 as per available records with the court. So, my lord, in my humble submission, there is no undue delay because Supreme Court has never said that 1 year, 6 months is the criteria. Depend on the cases. So there are various reasons why delay to it. And so far, and my lord, we have to see how many witnesses yet to be examined. If we go by the record, my lord, there are only 4 witnesses yet to be examined till 30/11/2024. Now, what happened, I don't know, because there is not. So, my lord, already 4 witnesses are examined. So, there is no delay. So far, my lord, this ground is concerned. My lord, section 50. That my lord already decided, my lord. The only thing is that, my lord, these are NDPS cases, my lord. When the person, my lord, is my assumption only. When the person carries the good contraband, he already knows that this is contraband.
Obviously, that is my view also. If he has carried the good and why he was arrested, these things are within his knowledge. But the view of the apex court is that it should be in a written form, it should be intimated. These are the view. Otherwise, if you see a person is behind the bus, as you have said, that more than 1 year, 9 months. So obviously the reason why he will not know. It isn't definitely is known to him, but that is it. Yes, obviously. Technically, it is technically.
Law incarceration is concerned, my lord, there is no delay. Because Supreme Court has never said in any case, if you have completed 1 year, 6 months, I will grant bail. Because the case to case, it will differ. And there are 2 points. Delay in trial and there is no possibility of concluding the trial. If your lordship goes to the Muhammad Muslim judgment and other judgment, those are 2 things, my lord. But here, if you see, there is possibility of concluding the trial. These are my humble submissions. And section 37, obviously.
So, this order Koregoni, this is my Korean show you. Kali program incarceration ko matipini headed para a lipak para this my complete concept. This okay problem hardly fit of Kali. It is submitted by Mr. Ahmed.
So M.A. Chaudhary.
Oh, sorry, Chaudhary. That M.A. Chaudhary, Mr. Chaudhary, that the present accused petitioner is innocent and he has been not committed any such offense as well as in the FIR. As per allegation, 25 cases of ganjas were recovered from the person of the accused petitioner. However, he is in custody since last 1 year, 1 year, 8 months, 19 days. 19 days. Out of CS was submitted on 21/12/2023 and till date, only 4 witnesses have been examined by the prosecution. Accordingly, for completion of trial, there will be the considerable period will be required. Considerable period will be required to complete the trial. In that context, he also submitted the Honorable Apex Court in various judgment have granted bail in similar cases, considering the long period of incarceration. And in that aspect, he relied on the following decisions. These are the decisions. Mr. Chaudhary further submitted that apart from long incarceration, the present accused petitioner was also not provided with, was not intimated the grounds of arrest at the time of issuing notice under section 50 CRPC, as well as at the time of issuing his arrest memo, which is in violation. Baki khini paragraph lagai dibo. So accordingly, so and so kori dibo. Next, ekhine khali mo short kari dibo. Mr. Kaushik, the learned additional PP, RR Kaushik, Mr. Learned additional PP submitted in this regard that within 30/4/2024, from the date of filing of the charge sheet, 4 numbers of witnesses are already examined by the prosecution, and thus the trial is progressing in a good pace. And there good pace, and there is no undue delay in the present case. Further, he submitted that there is to the Supreme Court never said any said that the long incarceration period of long incarceration should be considered as 1 year 6 months, or there is no such criteria, and the orders were passed by the Honorable Apex Court considering the facts and circumstances of each case. He further submitted that there is every possibility of completion of trial within a reasonable period, and hence the ground of incarceration may not be applicable in the present case. It's a case under section 37, rigor of section 37 will attract the agot ase the Baki khini probate forecast aro exam kora. Okay, we'll pass the order. I have dictated one from it is I'll pass the order. Hizo ko सब पे complete हुआ 14. Pardon,
I'm on behalf of Mr. N. Mahajan. His amicus curiae in this matter, madam.
Oh, you are appearing as an amicus here.
No, madam, he is N. Mahajan.
He is appearing on behalf
Behalf of N. Mahajan.
And Mahajan.
He's like in other court, madam. Can be after some time.
Or you need request some time.
Again. He's coming, madam.
Oh.
He's like in other court.
What time be? Someone.
50.
May please.
No. Yes.
May please. In this case, the petitioner was arrested on 10/7/24, my lord. He was, my lord, behind the bar for
10/7/2024,
my lord. Today is, my lord, 267 days, my lord. 267 days.
7 days.
My lord, what happened, my lord? Here the allegations mainly, basically, my lord, against the husband of the, my lord, petitioner, my lord. And while the husband of the petitioner is absconding, my lord, and the police could not found the husband, my lord, the police arrested the petitioner, who is the wife of the, my lord, main accused, along with the 3 years old minor girl child. The, my lord, problem is, my lord, as regards the, my lord, minor child, because the record shows that she had, my lord, suffered various ailments. My lord, the minor child is also, my lord, in the jail custody, and including, my lord, the second pox. That is, it is reflected in the record. I have checked it, my lord. And now, lordship will find page 21.
in the last paragraph, the facts has been reflected. Page 21. Lordship, in the last paragraph, may I read, my lord. I, along with the above mentioned police personnel and the independent witness, have arrived at the house of Sri Ankur Das, situated at Gorguri, Titapur, at 5:55 p.m. In the meantime, SDPO Titapur, Kakoli Patgiri and OC Titapur have arrived at the PO, and I acquired the authentication letter from the SDPO Titapur, Kakoli Patgiri. I have offered myself and other police personnel to be searched, and after that, I have informed about the purpose of their personnel search as well as house search. However, prime accused, which is Ankur Das, my husband, fled the scan before we reached his house. Then notice under section 50 NDPS Act has been given to his wife, Sangita Das. Since Sangita Das is a lady who is also wife of Ankur Das, and the body search was done by WSI so and so. After the body search of Sri Sangita Das, no any article was recovered from her possession. This is important news. Then house search in the presence of the said independent witness and from a secret storeroom, the present in their bedroom or their house found one large plastic bag containing suspected ganja. Then upon further search, 2 more packets, each of them also containing suspected ganja, were recovered respectively. The aforesaid mentioned items were in front of the above mentioned independent witnesses and found that the large plastic bag contains so and so, so and so. Here, Lordship, find that the ganja was recovered, not my possession, though it was recovered in the, my lord, from my house, but my lord, is not amount to conscious possession, my lord. And so far, my lord, charge sheet has already been submitted, and my husband also arrested, my lord, subsequently. And the only, though total 9 witnesses are there, only as per my instructions, only 1 witness has examined. My only that is, my lord, one Torun Koya witnesses has examined so far. And my the only concern is, my lord, as regards my girl, minor child, my lord, is 3 years old. My lord, the one of the coordinate events of our High Court, my lord, has already passed on the similar facts that the wife has been arrested along with the minor girl. That is considered by this honorable court, my lord. Lordship, my humble submission that the so considering the minor child of the petitioner, who is also, my lord, in jail custody along with the petitioner, my lord, and she has suffered various ailments, including chickenpox. It is reflected in the record. And my lord, in the last occasions, this honorable court, my lord, called the up-to-date case diary. And the only query is that whether any other witnesses has implicated me. So far the allegations part is concerned. I have checked the record, only the statement of husband of the, my lord, petitioner, with the prime accused has been recorded. But the husband has never said my name. Is only one Mintu has reflected. It has been flag mark also, my lord, may peruse that part. None has implicated me, and the possession was not from my custody. So it was in my house, but it was not within my knowledge. And I have not done any such offense.
Firstly, I wanted to state here, Lordship, the quantity is 23.706, so commercial quantity. Yes. Moreover, Lordship, if we look into the section 54, Lordship, and moreover, yes, it is true, from her body search, nothing has been found. But in the house, Lordship, this contraband has been found, so it is in her conscious position. Moreover, Lordship, the independent witnesses, I have looked into the CD, Lordship, they have implicated that she is there, and in their presence, they have seen that the person, the accused person is there when the search is made, Lordship. So, moreover, I want to focus on one other point, Lordship. If we look into the 24, that is the forwarding reports. She has stated in point number 3, Lordship, page 24.
Point number 3.
the accused person disclosed that that her husband, Ankur Das, deals with the sale of ganja and NDPS for a long period, and he was arrested twice in connection with the case under NDPS. The arrested accused person is acquitted with this illegal act of her husband, and she was supported him in ganja during investigation. That means, Lordship, she already knows that her husband dealing with this type of things for a long period. She has not informed to the police, Lordship. As a civilized person, Lordship, she has informed it to the police station, Lordship. She has not. Moreover, if you look into the 54 presumption from possession of illicit article, Lordship, it is clearly stated here in trials. Under this act, it may be presumed, unless and until the contrary is proved, that the accused has committed an offense under this act in respect of any narcotic drugs or psychotropic substance or controlled substance. And in the end, it is stated here, for the possession of which he fails to account satisfactorily. But she has not account satisfactorily fails how it came into her possession. So, Lordship, this is commercial 2037 will also apply. Lordship.
When CS was filed,
Lordship.
CS
Charge
filed,
sheet was submitted on
25.
Lordship. And charge, Lordship, next date is 4/2/2025. So there is no evidence till now, Lordship, has been deposed. In the
One is already been,
but in the scan copy, it is not there, Lordship. I have not know about that. In the scan copy, it is only stated here in the order dated 9/1/2025, 4/2/2025 for evidence. 4/2 last order. So I objected on this grounds, Lordship.
Section 54 is there.
And she has not discharged or rebut the presumption, Lordship.
I won't say that the 54 is will applicable at this stage because it is the case of trial, in fact. At the trial stage, if it is burden lies on the accused or the victim to prove satisfactorily or to discharge her burden in that process. So otherwise, presumption can be taken by the court. That is there in the 54. Anyway, point খালি লিখি বাকি লিখিব লাগিব।
Only one thing, my lord, the conscious possession means, my lord, the physical control and, my lord, mental awareness. Both are missing in this present case. So far.
The mental is there only. From if according report itself, prima facie, I don't know. Prima facie it reveals that one bag of ganja is lying in his house.
By the
How can you
investigation
say the mental position is
my
not
lord,
there?
forwarding report is by the, my lord, investigation.
Whatever, we are prima facie,
Yes.
we are on prima facie,
Yes.
we are on prima. এটা কাম করো। So note এটা লৈ লও। Item number 15, 15. So কৰি দিব। দুটা তিনটা point আছে। One is she got arrested on 10/4/2024. Behind the bars is 267 days. 267 days. Police was in search for her husband. And in his absence, the present petitioner, along with her 3-year minor daughter, was arrested by police. Her minor daughter is suffering from various ailments, including the chicken pox. And she is facing very difficulty along with her minor daughter in the jail premises. More so, she is not aware about that her husband deals with such and deals with the business of ganja. And from the from the forwarding report itself, it is seen that nothing has been seized nothing was recovered from her body search. So considering her length of detention and also considering the ground that her minor child is suffering from various ailments, she may be released on bail. একটু দিব আর এলোকর মতে দিব স্টেটর মতে Mr. Das submitted that from the grounds of arrest itself, it is seen that the accused petitioner was very much aware about the possession of ganja in the availability of ganja in their house, and she was also knew that her husband is dealing with the is engaged with in selling ganja, and thus the entire contraband was recovered from the house of the accused petitioner, and accordingly it can be held that she was very much conscious and he was very aware of about the contraband which was kept in their house. Full stop. CS was submitted on 25/10/2024, and next date was and in the last date was fixed on 4/2/2025. In this regard, the counsel for the petitioner submitted that one witnesses has already been examined out of 9 witnesses. Are baki hindi subjects.
One thing I want to clear here, in that scan copy also, one health report is there. Regarding that child of his daughter, it is stated that she has a overall good health and she is not suffering from any illness now. It is there.
Mr. Das also submitted that in the scanned copy of the record, one report is also received from the jail authority, wherein it is reflected that the girl child has a good health, and at present she is not suffering from any kind of ailments. Okay. Okay, I'll pass the order, just preliminary.
My please, Lordship.
Mm.
I am behind bar for 224 days. So, charges was filed on 30th/5/2024. Case under POCSO 4 and 366. Victim is 16 years old and accused is 21 years old. Out of love affairs, they fled away, and later on, the story turned around and story narrated as 366 and POCSO under POCSO. So, Lordship, charge sheet filed on 30th/5. I was arrested on 14/5/2024. After filing of the charge sheet, the evidence came on, the date for evidence came on 10/9/September. That is after 4 months. He was in jail. Charge sheet submitted on 38th. He was in jail, but date of evidence was first fixed for 10/9/2024. Then 8 occasions left. The victim girl, who was the main witness, she did not turn up, Lordship. Accordingly, I am the jail. So, Lordship, I am regularly appearing in the court from jail. So I will definitely appear. I'll consider my length of detention, my age, and the prosecution's sides endeavor to speed up the trial, Lordship. So on that ground, I may be allowed to go on bail, and I will regularly appear.
164, etc. are there, which was incomplete. This is also incomplete. What?
Half page, 1 page is there, and other page is not in the 10 copy, Lordship. It is just-
My humble submission is that, Lordship, in the petition itself, I emphasize that we are love affairs. I kept.
That's what I just want to see in 161.
Lordship.
Incomplete, Lordship.
How much is it? 824.
Submitted lottery. It seems like lottery, 154 segment, is being indicating. Big lottery may in last day. 154.
One?
Charge submitted, Lordship, and regarding there, some lights are there, Lordship, that what they stated in 164. But 164 I have not found. It is incomplete, Lordship.
কাকে দিয়ে নিলাম নাই
Lordship, come to the page number 9, that is the FIR portion, Lordship. Vernacular is on page 12. At 9:01 AM, she came with me. So, moreover, Lordship, she is 16 years. That's true. She may be.
Her consent doesn't matter.
Definitely. But 16 is somehow, in other cases, her consent is matter, but I left to this honorable court. Age is 21, she is 16, we were in love, and I am for 224 days in the custody. And victim is not coming to the court because of evidence.
In such cases, her statement, kill her statement.
Actually, I thought, as you have submitted, that there was a love affair and the girl is just 16, 17 years old, whatever. She gave her consent and they went there. But if you go by the, as is Mr. Das is submitted in the charge sheet, there are now implications are there. Then how she implicated against her will and all these are things are there. That's why I thought that if 164 is there, then it will be easier for us to pass an order. But 164 is not completed. That is the problem.
We have not received any report also, Lordship, regarding.
Report from?
Service report, Lordship.
Oh, service report is also not there. Oh,
I'm in jail, Lordship.
Huh?
I'm in jail, so.
no, you're in jail. Service report. We need the service report. Jail is okay. Service report is the report and the medicines.
It's also not incomplete.
Huh?
Moreover, 164 is also incomplete, Lordship.
Tips for this was not taken.
It was taken, Lordship. Notice to the victim person. If not today, I shall take steps.
I don't know, most probably inadvertently, the order of to issue notice was not there, in fact.
Exit.
That may be the reason why steps were not taken, but steps were not taken.
Gotcha.
Only the registry is taking steps for calling the scan copy. That much only. It reveals from the office note that this notice on the respondent number 2 was not taken. And inadvertently, the order was also not passed by this court for taking steps on the respondent number 2. The case relates to POCSO and it's the notice is to be issued to the respondent number 2 to judicial police station, routed to the office of the registrar and public prosecutor. And the petitioner will take necessary steps in this regard. Further, hearing the submission made by the learned additional people, Mr. Das, it is seen that the scan copy which is received from the concerned court below is also not complete one, and the some important documents like the 164 statement of the victim is also incomplete. Accordingly, the registry is hereby directed to issue reminder to the learned special judge to furnish the complete copy of the complete scan copy, record of the scan copy on or before the next date of listing. List accordingly, it will be listed after Bihu. We don't have any alternative. Before Bihu, we don't have any dates.
Let's try our luck with one.
No, we don't have any dates.
Also, with
Luck is different. Huh?
service maybe we that's the service policy.
No, it's a criminal case. How can it says one process is there, procedure is there. You have to issue notice to judicial police station, routed to the office of the registry and the public prosecutor. That is the issue.
In some
No dusting.
some other cases, lordship we took dusty service also.
In criminal matters,
Yes,
I don't know how it is
Pox-
given.
POXO case.
In POXO, I don't know.
Yes.
I don't know. I'm not on that.
Okay.
But you have to take steps in the proper forum.
Public.
That is the procedure now. Dusty is not allowed. Take step within 1 or 2 days, that will be you. And we are fixing immediately after Bihu. Immediately after Bihu, in a sense, we don't have any day. How can you fix? Yeah. 30 will do.
Is your lawsuit too long?
29, 28.5. 29.
Deeply letters.
Huh? I feel kind of. किसका कारण में लिखते लगेगा it will be laid upon it. In which we were 15 to keyboard. What about 15? Oh, check order, no? This is 29.4. It will last full one.
Wait, this is your lordship.
Yes.
Lordship, this is a regular bail application, lordship. Here, 2 years, 4 months in jail custody, lordship.
Hmm.
No doubt, it is a commercial quantity, lordship, 512.96 gram. That is 512 gram,
Gram of heroin?
lordship, 512 kg and 96 gram. That is the quantity of ganja recovered from the concealed part of a truck driven by the driver, lordship. This petitioner is a handyman, lordship. Now, lordship, what happened in this case? 4 person was arrested, lordship. When they Naka checking, lordship, they signaled this driver to stop. He ran away, lordship. He just to cross that Naka checking. Accordingly, this person were arrested, lordship. After arresting, lordship, the charge sheet has been submitted on page 22, lordship. Is the charge sheet, lordship. It is submitted on 4/3/2023, lordship. Although, lordship, 8 witnesses has been named in the charge sheet, lordship. Out of that, only 3 witnesses has been examined so far, lordship. Now, lordship, last witness has been examined on 11/6/2024. Thereafter, no witness has been examined, lordship. So, lordship, now considering the prolonged detention, lordship, as well as the ground of arrest, lordship, he was not communicated, lordship. Probably it is in the record, lordship. The copy has been served to me, lordship. That Xerox copy has shown, lordship, no ground of arrest. No ground of arrest has been mentioned, lordship.
In the scan copy you're saying?
Well, it will be there probably, lordship. Instead, LCR has called for scan LCR, lordship. That all, lordship, holding the lordship.
Your petitioner's name is?
Naveen Kumar, lordship.
Naveen Kumar.
Slow progress of the trial, lordship. Several date has gone, lordship. No, thereafter, no, except 3, none, further no other witness has been turned up to depose their evidence, lordship. Now, lordship, considering the slow progress of the trial and prolonged detention, lordship, and the regarding lordship that notice part, lordship. May I pray, lordship, this petitioner can be allowed and go on bail, lordship. Because several judgment and the direction from the Honorable Supreme Court as well from this coordinate bench of this court also, they are also observing that violation of the fundamental rights, lordship, that recovery from the truck, not from the physical position of this petitioner. He is a handyman, lordship. He has not control over the truck, lordship. It's the driver, lordship, who has a control over the truck.
Notice inspection, arrest memo, inspection memo আছে, notice নেই। For this particular, মানে, it used to be বিলাকৰ আছে। মেমোখন আছে, হেৰিখন নাই, notice নাই। You have not annexed any notice which you have received?
I have a copy, lordship. It's a receipt from WhatsApp, lordship. That's a Xerox.
No, I have found this inspection memo and the arrest memo
Yes, lordship. The
for the
arrest-
present petitioner Naveen Kumar. Arrest memo is here, arrest memo is with us.
arrest memo, the ground has not been-
No, your ground has not been mentioned, and 47 we are not receiving.
Yeah.
For the other two accused, there are notice. For him, notice is not there. Anyway. তারপর লিখে রাখি। 2 years, 4 months, লিখছে না? 2 year, 4 months,
My submission.
512 kgs, 96 gram. Was a handyman, not was in actual physical position over the, nor he has any control over the truck. CS submitted on 4/3/2023. Out of 8 witnesses, 3 examined. Last witness was examined on 11/6. Ground of arrest is not mentioned in the 47 as well as the arrest memo and inspection memo. Long incarceration or either ground is, please. Yes.
Is same as. Yeah, private vehicle motor position. Parting lies to him.
Pardon?
Parting lies to him. These are conscious possession. He was in the vehicle, right?
It's a handyman, lordship. It's not.
And these are the matter decided in the trial.
That's the lordship. Trial has not
Conscious
progressed,
position,
lordship.
state or motive. Several incriminating materials. 37.2. He's taking the ground that long incarceration one,
Yes.
and last witness was examined on 11/6/2024. That thereafter no witnesses could be turned up or examined. Though the petitioner is behind the person's class more than 2 years. That is your,
Yes, hold.
okay, rest I'll see to it.
Satisfaction of special judge Kamrup.
I don't know, order will be there only, then only I can discuss. How can we know?
Highly obliged.
Anyway, to one number 17, no? Oh, 18. 15 order holder. 19 and 20 votes affidavit are there. They are these all reached.
This section 52 of NDPS is very material with section 47 of BNS as well. Here the word is, my lord, as soon as possible. And if I am not wrong, the word there is forthwith.
There is difference, but the question is that you have to issue.
Yeah.
I mean, there may be some delay and delay has to be explained otherwise. Why it was delayed, why immediately your notice or arrest memo could not be served on him. There has to be some reasons. That has to be explained and more or less it has to be issued, maybe some delay may be explained. That is,
Yes, have to see that angle also.
yes, okay.
And that too, Lordship, it should be communicated in his language. He should
doesn't
understand the
understand.
language. Lordship.
These are now,
Highly obliged.
Wait, please.
19, 20, look at one more matter is there, no? 20 with 20.
No, now, which is called?
46.
20 and 40.
46.
No, my lord, now which one? Now 19 is only, 19 is not tagged with any other matter. 19 is different. My lord. Is it कागज तो किसे?
In fact, two PWs have been examined. One is a CW court witness.
This is my case. And kindly, my lord, come to page 19 of my additional affidavit. Page 19 of my additional, kindly. And page 20. This is a similar order where 6 months, 10 days, my lord. He was arrested, he was enlarged on this ground, my lord. And on the LCR also, my lord, we have flag marked the arrest.
So you have annexed only arrest memo. where
Arrest
it's,
memo, my lord, notice that I have flag marked it from the record, which was called from the court. I have flag marked both the arrest memo as well as the.
Notice is also there.
It is there. No problem. That's my case, my lord. Good time.
Your petitioner's name is?
Vidyanath Singh.
No, arrest memo is here. Notice is not there. No?
It is there, my lord. My junior friend have flag marked it, my lord.
Notice also.
Yes. Oh. Here, uncle. Which color? Green. Green color flag mark.
Achha. Okay.
That's fine.
Regarding 47 notice, my lord, then whatever whether the record says, my lord, you have to go through something.
Oh, one thing I just wanted to point it out. I mean, the quantity is, had it been 915 gram, 915 gram, point,
0.915 gram less, it would have been under intermediate quantity. 20.915 gram. This 915 gram has brought this case into
20.915.
915 gram. Had it been 20 gram, you would have been enlarged within 60 days.
46 kgs of ganja recovered from the three persons. All were together.
So those are matters of trial. Those I will not argue. Those are matter of
Otherwise, as a whole, it is 46 kgs.
46.895, almost 47 kilos.
different.
Case number 13 minus and extra to the BJP.
Annex page number.
But 13 and extra to BJP. No, the total ground over.
The segregation is also given. Those, my lord, will argue at the trial, my lord, whether, because there are judgments.
These are matter of trial.
There are enough judgment which says that for conspiracy, there has to be positive evidence.
Supreme Court also says, my lord, it is very difficult to prove conspiracy.
Yes.
With direct evidence, my lord.
Yes. Because I don't find any mobile phone, nothing of that sort is there. So conspiracy, I'm sure, my lord, trial, they cannot prove conspiracy. Because it's very difficult to prove conspiracy unless and until you name a person from where all of them has purchased it. You name a person where all of them are selling it. My lord, not for this case, just since he has, my lord, 3% raised it. Assuming me with two of my friends, we went to a particular place, we saw that somebody is selling ganja. I have purchased 2 kg for some Shivratri. Somebody have purchased 10 kg for selling. Somebody has purchased for some experiment. For 3 different purposes, they are bringing it. Now, just because they belong to a particular state, does it mean they are dealing in commercial quantity? So those things will come, my lord. Those things will come. For conspiracy, commercial quantity, they will have to have positive evidence. These are, I don't have to waste time of the court, my lord, because these are not germane for the present adjudication. I have given those materials, my lord. This is, in short, this is my case, my lord. And the judgment I have given, that judgment takes care of all the judgments which have been passed. I need not burden your lordship by repeating the same thing. That's my case.
Any other submission? No.
My submission, my lord, as far as materials are concerned, there are sufficient materials, my lord. If it is a search case, charges them, trial is going on, my lord. Now 47 notice, my lord, I'll go as per the record, my lord. Whatever record says, my lord, that I have to submit from this as per the record.
I'm obliged.
Note এখন DD setup by developer. My current DNA extract.
Along with 46.
This is my case. This is first one is item 20, and these are out of the same FIR. These 3 persons were apprehended. Here also they have clubbed up 2 kg, 10 kg, everything they have clubbed up. I have given the segregation also. In item 20, my lord, only 10 kg was recovered from him. In item 46, 2 persons are there. From one, 2.574 kg, and from the other, 10.32 kg. 2.73 and 1 year, 8 months they are in custody. Till
Why they are connected? These are out of same.
same effort. And no witness has been examined so far. 1 year, 8 months, 14 days. And this is my case, my lord. I have given one charge sheet and everything. And I have flag marked the arrest memos of all these 3 persons along with the notice in the record. The grounds of arrest has not been communicated. And I rely on your lordship that 6 month, 10 days judgment, which I have already annexed with that case. That's my humble submission, madam.
Regarding my lord, grounds of where I'll go by the record. Regarding following incarceration, my lord, Supreme Court has not very interested, my lord. Then after my lord passing 1.5 year, my lord, every accused person has to be 1 year released on bail. My lord. So last, my lord, I have seen my 11 man also Supreme Court granted bail, my lord. But these are not physical, my lord. This is not that, my lord, every court will have to follow this order, that means, my lord. And under what circumstances this order was passed, my lord, that is, my lord, will not know, my lord. Anyway, my lord, with all respect, my lord, if he is, my lord, placing this bail application, my lord, on 47 notice, my lord, then I'll go by the record, my lord. Otherwise, there are materials, my lord, it's a such case, my lord.
No witnesses have been examined so far.
Okay. 20, 46, 19.
So-
Okay, order.
Prolonged incarceration, your lordship have sufficient judgments, my lord, in other cases also. I'm relying on all those cases. I don't want to burden the court with all those things, my lord. And your lordship's order has taken care of all the Supreme Court judgments regarding that 47 and 50. I'm deeply obliged.
Disposed to বাদ document বহুতটা হলো order করে আর সব নম্বরটা
Kept it here. It's 5 actually. Do you want?
May I please to brush?
Yes.
In this case, my lord, I am seeking bail on 2 grounds. One is, my lord, arrest procedure is not within the legal framework. And second is prolonged incarceration. Inordinate delay of trial. So, my lord, my humble submission, my lord, kindly see. So I have filed additional affidavit, my lord, which is on record. No specific ground is mentioned in the notice under section 50 CRPC.
No specific ground mentioned, section 57.
And arrest memo also is there, my lord, page 62. And in this regard, my lord, I would like to place a recent 2 judgment in respect of arrest procedure, Bihans Kumar and Ashish Kapoor. Ashish Kapoor passed on 20 March, my lord, recent judgment. And my coordinate judgment, proceeded in Government.
50. Yeah, yes. And prolonged incarceration.
And it's Dhirendra Kumar Chaudhary. His judgment. This hard copy, my lord, I will submit just after 3 minutes. I will collect it, my lord, submit later, just after 3 minutes. So, so my lord, arrest procedure is not within the legal framework, and the petitioner has been in custody since 7/10/2023. And even my lord, charge is not framed. The next date is fixed on 5/5/2025. My lord, kindly see the order which is on record. Next date is fixed on 5/5/2025 for CC.
5/5/2023.
So on 5/5/2025, my lord, I am almost 1 year, 7 months. And even the charge is not framed yet. And in respect of my lord, no.
As not yet framed. Next date is for CC on 5/5/2020.
And my lord, no person is absconding. All 3 persons are arrested. So question of inordinate delay of trial is not fatal in respect of prosecution. Prosecution's case is that there is no ground in respect of inordinate delay of trial. It is a clearly case of inordinate delay of trial from the part of the prosecution. So my lord, my humble submission, my lord, I may deserve bail, my lord, in arrest procedure.
Your petitioner is behind the bar since when?
7/10/2023.
7/10/2023.
On 5/5/2025, I'm almost 1 year, 7 months. Even charge not framed.
7/10/2023. Till date charge is also not framed, though no persons are absconding. And next date of framing of charge is fixed on 5/5/2020.
The Ashtika for judgment that I have highlighted, the Supreme Court says that ground of arrest, it is clearly says that, my lord, that the said arrest memo cannot be construed as a ground of arrest, and no other worthwhile particular have been furnished. That cannot be, is clearly, my lord, in recent subsequent judgments. So I will furnish, my lord, two other judgment hard copies. This is my subject.
Yes.
Regarding long incarnation lordship, my old friends have already stated that it is not a precedent lordship. Every case deals with each merit has different lordship. Moreover, I have seen lordship 50 is there, CRPC. There is nothing, so ground is there. But at the same time, lordship, I also flagged 150 of NDPS lordship. Lordship may go into that lordship. There it is stated that that he is why he was arrested lordship because narcotic drugs has been found in his possession lordship, so they want to search his body. So I only wanted to state here lordship, the objective of 47 or 50 is to inform the person why he was arrested. Whether ground of arrest is a different thing, it is a matter of interpretation, whether this will suffice or that will suffice. Lordship. But if in my humble submission, I wanted to state here that lordship, through section 50 of NDPS, he came to know, he is informed that why he was arrested lordship. Otherwise, it is a matter of record lordship. The objective is fulfilled.
I read in many judgments, Supreme Court says that if section 50 CRPC applicable in NDPS cases, in all cases.
So we are on 50 NDPS Act.
At the same time, it was also given to him. So the objective is this information is there or not. In other cases, I am not talking about because section 50 is not there, because they are not informed on that ground. Search is not made at the same time. But in this case, he was already knows. The objective is not that lordship is illegal. But here lordship, he was main objective. To look into the main objective, he need to be informed why he was arrested. Ground. Here lordship may look into it 50. It is stated there, lordship. Format may be different thing, lordship. But the main idea of the Supreme Court, Honorable Supreme Court, it is that lordship, that the accused should know his rights so that he can defend himself. And in my opinion, humble submission lordship, yes, it is true, 50 it is not there, CRPC, but the hidden objective in that term law. Otherwise, 50 is not there. I agree with that. I will go by the record lordship.
Mr. Das was submission, beleg submission at a submission level. So that's what is submitted that long incarceration ago submission over again. 50 that submitted that at the time of his search, or seizure, he was served with a 50 NDPS notice of 50 NDPS notice, wherein it was informed that why the search was made, and the very objective of the is thus fulfilled, and the accused was aware about the grounds as to why he was searched and arrested in connection with the particular case. And even if there is no, there may not be any proper compliance of section 50 CRPC, but while issuing notice on 50 NDPS Act itself, fulfill the ingredients, fulfill the purpose and objective of the arrest of the particular person. Accordingly, he raised objection.
And in long incarnation, but it is
Yes,
not
I-
a precedent.
perhaps.
My lord, 50 CRPC is not equated with the 50 NDPS. 50 CRPC is a fundamental right, Supreme Court says in Bihar. So my lord, that cannot be covered up. My lord,
Yes,
and
submission.
my lord, my lord.
Liquid diplomat in this context, Mr. Chaudhary submitted that a 50 NDPS cannot be considered as a notice under section 50 CRPC, and the objectives are also different.
Twenty-three.
May please, Lordship. Matter may be taken immediately after vacation, Lordship.
After vacation,
Lordship. Immediately after vacation, anything.
at the request made by learned counsel, Mr. M.I. Hussain for the petitioner, list the matter, yes, and immediate 21, 22, 23 ways may not be possible because lots of matters have been faced, you know, I think. So at best it can be on 28, 29, 5 minutes aside. 29. It can be 29, 29 for.
Obliged.
24.
May please, your Lordship.
Notice is already served?
No, Lordship, actually, office note shows that we have not taken step, Lordship.
Oh. But we have received this scan copy, I think.
Still go be received, my lord. They have not taken any.
Lordship, otherwise in the same copy, Lordship, for 47, 48 notice, I mean, Lordship, 50 and 58 notice is there, Lordship, where no ground of errors is mentioned.
But you have not, why don't you have observed the formalities also?
Lordship, due to some miscommunication, Lordship.
Heard Mr. K. Thakur, the learned counsel for the petition. From the office note, it reveals that the steps are not yet taken by the petitioner side. However, the scan copy of the SI has already been received. Issue notice immediately to the respondent number 2 through registered through jurisdictional police station routed to the office of the registry and the public prosecutor. But it has to be fixed after Bihu only. We don't have any dates.
Lordship, then Lordship, 2 weeks or 3 weeks may be given, will be listed accordingly.
Immediately after Bihu will do?
Lordship.
Immediately after Bihu. You take steps, we will see.
Deeply obliged.
25.
Not legal, Lordship. The petitioner is behind about 57 days, Lordship.
No, it's okay. Have you taken steps?
Yes, I have taken steps.
What about the steps?
Awaited, Lordship.
Services, everything.
Everything.
Your petitioner is behind the bar since?
57 days.
He is 57 days. What to do?
Lordship.
No, we are on only period of detention only.
Detention, Lordship. You have not received, Lordship.
Is it a case of 60 days, I think?
50 days, Lordship. 8
50
o'clock.
days. We tried through our office, but the police officer stated that he will give some number to our office, Lordship, but he has not.
It's okay. It's your service is awaited.
Lordship, then.
Pardon?
At 2, I will take instruction again, Lordship.
I mean, what kind of instruction?
Whether
Regarding service?
or not.
Regarding service is okay, you will take instruction, but the question is that he is behind the bar for 57 days. That is the question. So from the is there anything that going to be filed within 2-3 days? That is the
Yes, it is there, Lordship. One, Lordship, FSL is there. FSL regarding victim Kapoor blood stain, Lordship. Blood stain in the victim dress. That need to be come from FSL, Lordship.
FSL is not yet received.
Not yet received, Lordship.
Then probability of within 2-3 days is very less. That's what I'm saying.
Moreover, otherwise, Lordship,
Materials are there.
Injury is there.
The materials are there.
Lordship, may kindly see the FIR.
But why it is 8 of the POXO then? I don't know, is it a 8 of POXO or 6? You just see.
6. It should be 6, Lordship.
It is registered under 8 or 6?
8.
How it can be 8?
Lordship, if
Again, the guard, Lordship. There is nothing in there.
FIR page 7, Lord. Kindly introduce the FIR, Lord. So I am only on the ground of detention, Lord, length of detention.
So you are saying bloodstain was there?
No, Lordship. In the medical report, Lordship, injury is there on private part. However, Lordship,
Injury was in private part.
Lordship, it is clearly stated.
Okay, then how it is 8?
Lordship,
Do
give
one
me
thing,
some
you
time,
take
Lordship,
instruction.
then I will also take instruction.
You
and
took
fix
instruction
this.
whether
Lordship.
any sections is added or not.
Lordship, Lordship.
If bloodstain is there, it's a very serious
Lordship,
nature.
it is true, Lordship.
At 2, okay.
At 2, Lord.
26.
Matter may be adjourned, my
After Bihu it will come.
lord, before.
No, before Bihu don't have. Please, we do not have any.
Well, adjourn for the day, my lord.
Before Bihu don't have, after Bihu it will come after Bihu. After Bihu, 20. After Bihu.
My lord, my
after-
humble submission, my lord, this, it is, matter is that the co-accused bail application was disposed of by Honorable Justice P.J. Shwetiya. So for
Then
this,
can it be an appropriate bench?
so.
Because bench is available now.
Bench is available. So my
Okay.
humble submission matter will be adjourned and it will be decided by the registry. Adjourned for today.
Adjourn and better will be decided. It will be maybe before listed before appropriate
Before
bench.
appropriate bench, that can be done.
Okay, in that case, I can give you a date. I don't know what is the date.
Fine.
7 can be Borborwa. List the matter before appropriate bench on 7.
On my 9th.
Okay, list the matter before appropriate bench. Okay, okay.
Obliged.
27.
And 677 days, Lordship. No witness has been examined, Lordship. LCR will reveal that. Next day is from 3-6, Lordship. Prolonged intersection is there. Lordship. No witness has been examined out of 8.
How many days you have custody?
677 days, Lordship.
677 days. And
26/5. 23 was the date of arrest.
20?
26/5/20. And he has subsequently filed on 29/20.
29, 23. Charge when charge frame?
31/5/24.
31, 5, 20? 31, 5,
24, Lordship.
24. Charge frame.
No, Lordship, yeah.
31/5/2024 charge frame.
31/5, yes.
Yes, 31, 5, 2024. Till now, no
No witnesses.
witnesses.
Next day on 3/6/25.
Next date is 3.
3/6/25.
How many witnesses?
18 witnesses.
Yes, Borwa. Is sufficient.
If he is paying for my lord bail and the grant of long incarceration, my lord, then my submission will be same, my lord, because my lord, it is also precedent, my lord. Pursuant to the, my lord, observation made by the Supreme Court, my lord, Honorable Supreme Court, my lord. Regarding my lord, the search sheet case, my lord. Yes, my lord, there on 31/5/2024 search sheet, my lord. And no witness is examined till now, my
Till
lord.
date.
That is the report, my lord, dated 25/3/2025.
PW is absent on the last date also. Very absent. I leave it to your Lordship. Any condition, Lordship, we will cooperate, Lordship.
Especially from Karimganj, it seems that the evidences are not taken in some, there are some districts where the case is going in a good space. Especially in, I thought some most probably Karbi Anglong is also going in a good pace and some there are some, but Karimganj is quite difficult. Pendency is also high, I think so. And though no separate court of NDPS is also there. And another difficulty is that as I am from the trial judge, that say hardly 2 or 3 witnesses can be examined entirely whole day because it takes time. There are lots of exhibits and all, so it takes time. That may be one of the reason, but from Karimganj, I'm saying that
24 May, my lord, last year 24 May, it charges it payment till there, my lord, nothing.
yes, so that is very
My
surprising.
question is that, my lord, when, my lord, they seize the, my lord, contraband, my lord, they call the, my lord, nearby witnesses, my lord.
Yes.
Nearby, whoever they may be, my lord.
Mm.
If he is not resident of that locality also, my lord, they just, my lord, call that and put their obtain their signature, my lord. Now, my lord, their address is very much vague.
That is was one.
My lord,
Mm.
very vague.
Mm.
Suppose, my lord, if I say that I am a resident of Gujarat, my lord, can you please hard it up to me, my lord?
No,
It's not
no.
possible, my lord.
Mm.
I have to give house number, then my lord, land number, my lord,
Obviously.
then local police station, my lord. So these are the, my lord, some sort of what I have found, my lord.
Yes.
These are the maybe, my lord, reason for why, my lord, witnesses are not turning up, my lord, or some, or for the reason why the someone could not be served up from there.
No, in my case, someone has been served. Lord. The accused
Witnesses did not turn up.
Yes, one occasion he was appeared. Lord.
But he could not be examined.
Yes. Annexure I, Lord, page 37.
Yes, he could. He was not examined.
That's not my lord.
Yes.
Why it is not examined.
Because he was present, so he was present before the court only to adduce evidence. That there may be some ground on the part of the court also.
Yes.
That is not there. Anyway, pass the order.
Yes.
I will also give you one format. You have to both button by himself. Because similar kind of orders are there. So I will also give you the format to take the format from the try to type it. This one I just left it. Otherwise you see. Yeah.
28.
Wait, please, your lordship. This is an application under
Ms.
480.
Decca, you are going to appear here.
This is a 483 application, your lordship. The petitioner was arrested on 24/6/2023. Your lordship. So it is more than 1 year, 9 months. Now, your lordship, under section 20B2C, 29 NDPS, your lordship, 161.17 kgs of ganja was recovered. But it was not recovered by the petitioner. It was recovered from a truck which was driven by one Amirul Khan. Then ultimately, your lordship, during investigation, the petitioner's name was one of the co-accused. Pramod Kumar has named the petition. And therefore, your lordship, he has been called under section 67 to the NCB office, and there he was arrested. This is basically the case. Now, your lordship, the second point that your lordship is that there were 9 listed witnesses, PWs. Out of 9, 4 were examined. And the last 3 were official of NCB. 1 was the scientific officer. The scientific officer was of FSL was your lordship. His evidence was taken in August 2024. From then, for the last 8 months, no evidence have been taken, your lordship. So this is one part, your lordship. Second part, your lordship, he was subsequently arrested, and there is no money trail involved in this matter. Thirdly, your lordship, none of the PWs, which the 3 your lordship officers and the scientific officer, they did not implicate the petition. They have all implicate the main accused person, Amirul Khan, who was arrested along with the contraband. Now, in this case, your lordship, another angle was taken up in a co-accused have filed an application before your lordship, and your lordship has already granted bail to the co-accused who has actually named the petitioner. He was also granted bail by your lordship on a ground that is violation of section 50, which is 47 BNSS. I am also taking the same ground along with the other factual part, your lordship, that I am taking. And your lordship, in that case, that was, I think, 2-3 days back, your lordship is given the judgment. Same FI. He is one of the co-accused who was named by the main accused, and I am one of the co-accused named by that accused. So that is the whole issue. The mainly other things are exactly the same in that case and this case. And in fact, your lordship has referred to 2 judgments in that matter. In fact, here I would like to point out one thing, the memorandum of arrest that is at page 35. Lordship will kindly see, because I'll also point out another judgment of the Honorable Supreme Court, which was given last week. I'll also point out, that is why I'm putting it before your lordship, memorandum of arrest is page 35. Yes, this is the memorandum of arrest which was served on the petitioner, Madhu Rai. His signature is there. This is the document which was given to him on the time of his arrest. Now I will refer to a judgment, your lordship, of the Honorable Supreme Court. This is a very recent judgment. This is delivered last week, your lordship, by the Honorable Supreme Court. Apart from that, which your lordship has already given in the other judgment, I am additionally giving one judgment, very recent judgment. That's why I am giving this. Here, your lordship, it's a short judgment, not a long one. The grounds that was taken is, one of the ground was section 50 of the CRPC. Now it is 47. That your lordship will find at the next page. Here, what has the Honorable Supreme Court has said, the arrest memo cannot be, your lordship, that is the next page, page 2, your lordship will kindly go and see the paragraph, 3rd paragraph in that. It has specifically stated here. I'll just read that. Everything annexed, you can see that has been provided to the appellant only and arrest memo in the prescribed format. It is then to be given to the appellant by way of distribution. That has been filled up with a name of the appellant along with the place of arrest, which means that he has been based on the we are in agreement with the submission later and senior counsel. Hearing for the say arrest memo cannot be considered as ground of arrest. As no other worldwide clear clear non-compliance of it has been introduced to give effect to Article 21(1) of the Constitution of India. 92, we are inclined to set aside the impugned judgment, particularly in light of the judgment rendered by the court in Probe Pucaste. Probe Pucaste, your lordship has referred in your lordship's judgment. In view of such matter, the impugned judgment set aside, arrest of the appellant, followed by consequential remand order has also been set aside. So, your lordship, further, in this case, the arrest memo has also been, the court has discussed with regard to the arrestment that cannot be without there being specific grounds of arrest. So, my humble submission, your lordship, similar matter, your lordship, similar order can be passed along with the observations in this matter with regard to the judgment of the sovereign.
So your lordship, the rule is different, lordship, involvement is their lordship. But lordship, on the ground of section 50, you have already lordship granted bail on one. Lordship, we have placed 2 judgment earlier on that. You may consider this that.
Earlier also you have placed 2 judgment, I think. One.
Yes, lordship has recorded both these judgments.
Kashif was there, I think. And the Spellan Chandra.
The judgment to be considered.
বাকিখিনি আপনি আপা লিখিব পাৰিব সেম মানে অবজারভেশন উইল বি সেম বাকি লিখক আপুনি হার্ড মিস্টার ওয়াইএস বান্নাম The learned counsel for the petition also heard MS M. Deca, the learned counsel appearing on behalf of the standing counsel LCP. It's an application can live so and so, so and so. You can write it down from here only, same out of same effect here also. Scan copy of the case record has also been received to same hard consent. It is submitted by Mr. Mannan that the present accused petitioner was arrested in connection with this case on 24/6/2023, and since then he is in 23 and 23 full stop. But nothing, no contraband was recovered from the conscious possession of the present accused petitioner, and he was arrested only on the basis of the statement of the co-accused, recorded under section 47 NDPS Act, which is not admissible at the time of trial, and it cannot be the basis for conviction. Is laid down by the Honorable Apex Court in case of Tufan Singh versus State of Tamil Nadu, so and so already. That I say already. Yeah. Further, Mr. Mannan has submitted that Bakita ground same takibo, non-mentioning of ground. These are here. Last Mr. Mannan further submitted that the one memorandum of arrest was prepared and served to the petitioner, but except the intimation, there is no grounds of arrest was intimated to the present accused petitioner, which is also in violation of the provision of Article 21 of the Constitution. In that context, he also relied on a recent decision of the Honorable Apex Court, passed in Criminal Appeal Number 1518 of 2025, bracket or Divo, Ashish Kakkar versus UT of Chandigarh. Yeah, I asked already. Yeah? And he basically stretched on para in the following para, wherein the observation was made by Equint. Wherein it is observed that the arrest cannot be construed as ground of arrest, as no other worthwhile particulars have been furnished to him. It is further observed that the non-compliance of mandate under section 50 of CRPC, which has been introduced to give effect to the Article 22 subsection, Article 22(1) of the Constitution of India. And on the basis of the said observation and on the said observation, the arrest of the appellant was considered as arrest of the arrest of the appellant, and the consequent remand order is alleged to be considered to be illegal and accordingly set aside. কিবা থাকিলে মিলাই দিম আপোনাকে আৰু বাকি আপোনাৰ observation same থাকিব MS Decar submission more or less same থাকিব that will be the observation. Okay, we can continue.
Much obliged.
It would take it up to you. Yes. We can do it.
May it please your lordship. Lordship, this is also regular bail application, 210 days in jail custody, lordship.
Also, where appearing, someone appearing.
Lordship, regarding service, lordship, page 17, services.
Services submitted.
Otherwise, Lordship, we have taken step on the 20 March, Lordship.
20th of March.
March, Lordship.
We will make an inquiry then. What is the stage of the case at present?
Lordship, this charge sheet has submitted, Lordship, now for evidence, Lordship. Can you, before that, Lordship, can you peruse the page 25, Lordship, the statement of the victim, Lordship? A statement 164 statement, Lordship. Now it is 183 BNS. 25.
Yes, obviously. In 164. She did not say anything against it.
Against this.
How you got this 164?
Lordship, this is a charge sheet case, Lordship, certificate copy, Lordship, I have applied, Lordship. It's a certificate copy.
Yes, provide.
I have not received any report, Lordship.
Your petitioner is behind the bar since when?
210 days, Lordship, today, Lordship. He was arrested and forwarded on 6/9/24, Lordship. In the month of September, 6 September 24.
That is now ended that you have to hear the petitioner on site.
In that
This is the
case,
case.
Lordship, petitioner has to, the victim has to be assist the public prosecutor. When the public prosecutor is placing the case, Lordship, he has to just assist the.
No,
court,
whatever,
Lordship.
whatever, that is the, that is
Because,
the
Lordship,
notice.
we have taken the step, Lordship.
That is the notice, what to do. You may be other side. Otherwise, I have seen the
Yes.
statement.
Yes, Lordship.
So you want to make an inquiry here? Because as per him, he took steps on 21st of March.
Lordship, it's a 20th March, Lordship.
20 March.
May I pray for Lordship before you, Lordship?
No chance.
Because they have to only take the instruction, Lordship, whether the survey, copy has been served.
No,
or
we
not.
have to pass the order. no?
Yes, Lordship.
We don't
That-
have any.
That
space.
instruction they can obtain through.
They can obtain. You can also obtain, but we don't have any. Main issue is there. You can see the cause list, how many matters are
Yes,
hearing
yes.
matters are there. It's not possible on our part. We make an inquiry. Note as per note from the officer, it is seen that the service is still awaited for the respondent number 2. Mr. Das, the learned additional PP is hereby asked to make an inquiry in regards to service of notice on respondent number 2. On the next date, if the victim does not appear, there may be an order for appointment of amicus. We may be here on the part one. Okay, at least opening day, I'm fixing it on 21. 21/4. No, hearing this, আপনি চিন্তা করার কি করি ফাইন Yes, Ati.
Here, Lordship, the petitioner is in custody. Lordship, may kindly take up the additional affidavit we have filed, Lordship.
Additional affidavit already filed.
Lordship. It's filed on 27th March.
Affidavit file করেছে বলে additional আমি জানি না Step. Yes, additional affidavit.
Page 27 and 28, Lordship, may kindly say that there is no grounds. ma'am. And this case is under UAPA that is squarely covered by Toby Precasta case. That
This
case
is also under UPA.
Yeah. The Toby Precasta case was PMLA and UAPA. This Kutker's case, Lordship, that earlier occasion also I have placed before this honorable court that there worthwhile that information has to be there, Lordship. Here nothing is there. The few minutes back, your lordship has read that part, phase 2. That here in this case, co-accused statement was, on the basis of co-accused statement, he was arrested. That was mentioned in the arrest moment. Apart from that, nothing was there. And Honorable Apex Court said that cannot be treated as a grounds of arrest, lordship. And here no such mention.
In which para particular?
Page 2, your lordship will find that that we are inclined to consider that starts from that paragraph. We are inclined to consider only the last issue raised by the appellant with respect to non-furnishing of the grounds of arrest. Upon perusing Annexure P3, we can see that what has been provided to the appellant is only an arrest memo in the prescribed format, which is meant to be given to the appellant by way of an intimation. It has been filled up with the name of the appellant along with the place of arrest. Additionally, it has been written that he has been arrested based upon the statement of the co-accused. We are in agreement with the submission made by the learned senior counsel appearing for the appellant that the said arrest memo cannot be construed as ground of arrest as no other worthwhile particulars have been furnished to him. And here in my case, lordship, it is only mentioned that you are found involved in the case, so you are arrested. This much. Nothing is there. Page 28, your lordship will find. They should disclose on what basis, what are the materials on the basis of which they can found that I was involved in the case. And in NDPS cases, that section 52 is there, that information has to be given. And in present case, lordship, 43A, lordship, it is there. 43B(1). Any officer arresting a person under section 43A shall, as soon as may be, inform him of the grounds for such arrest. And in fact, they have lordship, the grounds mentioned in the forwarding report also, they have copy pasted from other accused, including the photograph also. That photograph is of another accused. The forwarding report, page 11, your lordship will find. Photograph is of different person, only they have changed the name.
This is not his photograph.
Not for his photograph. They can verify from the record also. Case diary is here. Other accused persons for forwarding is also there.
Anyway, all photograph, all are same looking person. Similar looking. Yes, Burvani or assumption.
No, we have received the case very well. So if my learned friend my facing this bail application on the ground of section 47 BNSS matter. So my humble submission, my lord, in his bail application, my lord, he has not taken this job additional application. The bail file. When the bail application was filed, my lord, he has not taken up this job, my lord, that while furnishing the ground of various, my lord, the particulars has not been mentioned, my lord. And now, my lord, in this case, my lord, the IO has collected sufficient materials, my lord. My lord, since my lord, who is taking the application on 47, my lord. So I am not going much because my lord, possible.
Because this is a UAP Act and case is very serious in nature otherwise.
It doesn't connect, and my lord, during investigation, my lord, he has been arrested, my lord. Because it is the UAP Act, my lord, UAP Act case, my lord, because the person is arrested, my lord, during my lord, while the investigation is going on, my lord. Now, my lord, as per my lord, ground of various parties to him, my lord. In exercise of power conferred under subsection so and so 47 BNSS. I do have to inform you that during the investigation of Simola Gudi, PS case number so and so, under section so and so, you are found involved into the case and so you are arrested in connection with the above noted case. Reference on 4/2/2005 at my lord, this is black my lord. You will be forwarded to the honorable court within 24 hours. So it is mentioned that during the my lord, investigation of the my lord Simologuri PSCS number so and so, you are found involved my lord. And my lord,
Yes, obviously that is understood.
how case involved my lord, case my lord, I'll go by the record my lord. 47 notice my lord,
Obviously, Simulaguri case, he is involved, may be involved, but what is the case of Simulaguri? We don't know, suppose. And at the time of arrest, that is the thing. Otherwise, it is known to everyone that he is very aware about the facts of the case and the grounds of arrest. Not communicated.
Not mentioned in my lord details my lord.
The one thing also
And
that
as far as the materials are concerned, my lord, there are sufficient materials, my lord, we already collected my lord, against him.
only one thing also that by filing additional affidavit also we can raise this issue, and I'm not going into that aspect, but in my petition also that ground is there, paragraph 6 also of my bail application. At that time, documents were not there, so we could not mention it, but in the petition it is there, paragraph 6. Lord.
Paragraph 6.
6 of my bail application. Because of the Xerox copies were there, so we could not annex it. So subsequently, we obtained the certified copies and we have placed placed on.
Let's go by the record, my lord. Lots of they were noticed, my lord. As far as my other materials are concerned, my lord, there are sufficient materials, my lord. That submission may be recorded.
Okay, gotcha. So with this, how many was there? Huh?
11.
With this, 11. One will go to her and rest. Two. Which one? To this one also. She is getting. Yes, then in that case, I have to give some dictation to her. 6. 6. Already got 2. Already got 2.
So the dictation was.
Then this one we can give it to this Shabnam. Because there are some things that may not be available. His rest bail hearings are there. I think here in maximum matters, we have received there are some is scan copy of the case record in 2 matters are there, I think. 2-3 matters are there. And the rest
My lord, sir, today were lots of matter, my lord, skin copy has been come, my lord. So today working, we are two, my lord.
we are also overburdened. We have to work for the whole day. 8 will go, 46. This 46 is also over.
Yes,
Now 48 is there. 48 is last bill hearing matter.
yes, this one timing, I think 45.
45. 45 was time. Only one timing is different. Okay, we see. Yes.
Instead of SDGM M, Bishwanath Lodge. First production was before SDGM, subsequent on the next, on fourth, Lordship.
Accordingly, it is provided on connection of bond of friendship to the satisfaction of landed SDGM amount from landed system. And special just Biswanath. Should be. Landed special just Biswanath channel. It will please forward us.
Lordship, the special case number kindly be put, Lordship. Special case number is there, Lordship.
Huh?
Special case number is there, Lordship. The copy I placed, Lordship. Now it is special NDPS case. That copy, Lordship, just place, Lordship.
What to do? We have filed all these things subsequently. It is not our fault, no?
No, no, Lordship, that is right.
How can be incorporated all these things? Side devote and special justice case number 2.
Hello.
This one.
Item 2.
You want to withdraw. As per instruction of your client. Okay, it will be withdrawn, disposed of. Number 2, disposed of or withdrawn.
Except 2, item 1.
It will very division. 10 to BC होने पर. अपने भाई से की हो जाए.
Madam, item 1, I am appearing for 2, madam. I learned 21 and I'm 2. Number 1. Yes. No, number 1.
One you are appearing.
No, I am 2, I am appearing. Both of you are also say, but my learned friend will, 1 is a blind person, madam. Blind person. So that's why this may be taken first, madam. I'm for 2, madam, but he's the 1.
May I please, your lord?
What was with the blind person? He is not sitting here, no?
No, it will number 1 is blind.
Whatever, he is not before us, no? You are saying that his petition should be heard at first. He is not before us.
First, madam, because.
Document take up one first, my lord.
No, whatever. I'm just in your as per your number 1 also, Mr. Mahajan, his name is there.
Oh, my lord. Sir, do you know what is it? Oh,
You are in 2.
He is item number 2, my lord.
Okay.
Item 2, my lord. To be telephone dealer. To be again, may I please, your lordship? My lord, objection that is to be filed of whatever be it, my lord. He has already filed it, my lord. Primarily, there are on merit, my lord, with all respect, my lord. In his affidavit, I begin from, my lord, not from the beginning, but from in between, because the reason, my lord, in the affidavit, there was a dispute as to whether the GST Act itself is a complete code or not, my lord. There are a lot of high courts, my lord, having different views. Now, my lord, Apex Court, in the latest 25 authority, my lord, by the name of a lady, my lord, with all respect, my lord, it has been clarified, my lord. It is not a complete code, my lord. So whatever is stated in the affidavit is contrary to the present law, my lord, as has been laid down under Article 141 by the Apex Court, my lord, with all respect, my lord. So, my lord, notice under section 41A is a must, my lord. On technicality, my lord. Have I made my position clear, my lord? That is a must, number 1. Secondly, my lord, the grounds of arrest that remains, my lord. And my lord, in GST cases, there is a DIN number, my lord. There is no Apex Court on that, my lord. If the DIN number is not given, my lord, there is a departmental notification, my lord, that any document which needs to carry a DIN number, if it doesn't carry it, my lord, it is an exercise in nullity, my lord.
Have I made my question clear? And that has been held by, the same view has been held by the Delhi High Court, my lord, with all respect, my lord. And my lord, reasons to believe there was a dispute, my lord, whether it is an internal matter of the department or it is to be made known to the accused, my lord, with all respect, my lord. Law is now clear, my lord. It has to be made known to the accused, my lord. These violations itself, my lord, possibly lead to grant of bail, my lord. And on the factual metrics, my lord, with all respect, I would submit, my lord. When he was produced, there is magistrate's order. Even in the FIR, it is admitted, I'll read that, my lord, that one accused, the petitioner before your lordship, is 100% by, and there is a central government certificate, not procured now, my lord. Since generations, it is there, my lord. There cannot be any dispute on that, my lord. And on humanitarian ground, my lord, his wife expired during COVID, my lord. We have filed an additional affidavit. It is there, my lord. And on the top of it, my lord, he has got 2 school-going children, my lord. None to look after them, my lord. 7 except distant family members, my lord. These are the factual metrics and on law, my lord. And my lord, we have filed another affidavit wherein, my lord, because GST, my lord, they quote huge amounts, but ultimately, my lord, upon calculation, it comes down to a paltry sum, my lord. There are a lot of instances, my lord. And I have annexed, my lord, with all respect, my lord, not similar orders, my lord, orders wherein in GST cases, in small quantum of time, my lord, huge amount of money, more than this case, my lord, where even learned lower court below has granted the privilege of bail, my lord. On technical counts, my lord, that grounds of arrest path remains, my lord, because whatever document which has been used to show that grounds of arrest were provided to us, my lord, does not carry a DIN number, if I am not mistaken. On to support it, my lord, it is there is a government circular and a Delhi High Court authority, my lord, with all respect, my lord. And they cannot, my lord, with all respect, because the section of law attributed is section 132(5), my lord. The quantum of punishment provided is, my lord, is a 60-day period offense, my lord. Have I made my position clear? It's a 60-day period offense, my lord. And in this act, GST, my lord, there is no embargo. Like NDPS, Unlawful Activities Prevention Act, no embargo is there, my lord. And the entire case, with all respect, I would submit, my lord, is based on documentary evidence, my lord. Let me place, my lord, with all respect, my lord. So far as the FIR is concerned, my lord, it occurs at page 14, my lord. Panchnama, my lord. It begins from there, my lord. I'll be cryptic, my lord, to the extent possible, my lord. Page 14, my lord. If I read it in totality, my lord, yet total defalcation given. Here it is, my lord, with all respect, my lord. In this case, the quantum of defalcation, to be precise, my lord, 14 point by around 15 crore, my lord. Alice defalcation, my lord, 15 crore. There I read, my lord, this is their affair, my lord. This affair is lodged by the department, my lord, and signed by the first informant, my lord, and signed by the first informant, my lord, whosoever they may be, my lord, intelligence officer, that occurs at page 16, my lord. So they cannot retract on it, my lord, with all respect, my lord. There in para 2, I read, my lord, with all respect. Page 14, my lord. 14, my lord. With all respect, my lord. There I read second paragraph, to show his physical disability. We, the witnesses, along with the officer, so reached at the said address. The officers knocked at the door and was opened by a man who introduced himself as Shubham Jain, owner of the residence, proprietor Bahubali Enterprise. Thereafter, the officers introduced themselves to Sri Bhuvan Som and showed the authorization and search so and so. However, it is their admission, my lord. Sri Shubham Jain informed the officers of DGCI Guwahati that he is virtually impaired. Have I made my position clear, my lord? He is virtually implied. I turn the page, my lord. Next page. Thereafter, reading, my lord, leaving aside 2 lines, 1 line from the half line from the top, my lord. After going to the charge authorization dated so and so, both Sri Shubham Jain and Praveen Jha, other accused, my lord, affixed their dated signature on the body of authorization as token of having seen and allowed. That could not have been done, my lord. Anyway, Before commencement of the charge, the officer DGCI offered themselves to Shubham Jain for personal search, which was politely declined by him, as because he was blind, my lord. Apparent, my lord. And thereafter, I'm just placing it, my lord. And thereafter, the contents, my lord, there is at least defalcation to the tune of around 14 plus 4, around 15 crores, my lord. With all respect, my lord. Thereafter, my lord, I straightway come up to page 36, my lord. Had it been a case that, my lord, he was not blind, that plea should have been raised by the authorities. They have admitted in the FIR itself, my lord. We are virtually impaired, my lord. Now they kept plea that there should be a board. But anyway, that is immaterial. What I am placing, these are the, my lord, on record, my lord. Now, page 36 is a certificate issued by the government of India, if I am not mistaken, my lord. Government of India, and Assam government. Oh, disability certificate. My lord, this is government of India, my lord. He is joint director. Oh, sorry, Assam, my lord. Assam, I'm sorry, my lord. He is a case of blindness. My lord, he has 100% in figure, 100% permanent disability. Have I made my position clear, my lord? And this is the procured, not because of the case, my lord. It has been there since generation. It is dated 9/11/23, my lord. With all respect, my lord. And now, my lord, let me come to page 31, my lord. Because this plea should be nullified that he is not blind, my lord. He is 100% blind, page 31, my lord. There I read last but one paragraph, my lord. This is a magisterial order, my lord, of the learned court below when he was produced. The learned counsel for the accused, Shubham Jain, has submitted that the accused is a completely blind, and in support of his contention, he has adduced Xerox copy of disability certificate issued by GMCH Guwahati. The learned counsel, appearing for the Director General of Goods and Services, so and so, has opposed prayer of the accused person, has stated that merely because a person is blind, blindness is admitted, my lord, with all respect. They cannot deny it now, my lord. Blind, it cannot be presumed that he cannot commit the offense. I'm also not, my lord, no presumption need be necessary, my lord. Let it be ascertained during trial. And it is not an offense, heinous offense. There is no embargo in the act, my lord. It's a 60-day period offense during investigation, my lord. And he is already there, with all respect, almost a month, my lord. 29 days. And I'll place orders, my lord, wherein people have been released on huge quantum of money, even, my lord, during lesser duration, my lord. This is regarding sickness, my lord, with all respect, I would submit, my lord. Now I come to, my lord, with all respect, my lord, but kindly have a look at page 23, the forwarding report, my lord. Yes, yes. My lord, I'm sorry, my lord, let me come to a different page, my lord, the summon. The house was searched on 6th of March, 2025. Immediately next day, or on that day itself, my lord, summons were received, my lord. That occurs at page 17, my lord. Dated in bit, my lord, some lines below, my lord. 2025 3/6. Have I made my position clear, my lord? And he immediately appeared, my lord. That occurs at page 17, my lord. So the question of, my lord, running away or tampering with evidence doesn't arise, my lord. I appeared upon being called, my lord, and there kindly see, my lord, that DIN number is there at the top, my lord. Right hand side at the top, my lord. That is called DIN, means, my lord, document identification number, as has been clarified by Delhi High Court, my lord. The page 17, in this it is there, my lord, at the top. DIN, lordship has seen, my lord. This number is there. This number in any document necessarily issued by GST authorities, my lord, must carry this, my lord. I'll come to the notification later on. Next page, my lord. Arrest memo, my lord. Arrest memo, my lord. There is a dichotomy, my lord. Kindly see here the DIN number is not there. Oh, here the DIN number is there, my lord. Sorry, my lord. DIN number is there, my lord. DIN number is there. There, kindly see, my lord. Because I'll place an authority by which apparently regarding search, seizure, arrest, my lord, Code of Criminal Procedure is applicable. The plea that GST Act is a complete code in itself, my lord, is nullified by the apex court, my lord. So, my lord, the Code of Criminal Procedure would apply. when the code of capital procedure applies, my lord, then, my lord, the grounds of arrest, that it has to be. I am not to say in so many words, my lord, that section 47 document would come, my lord. Have I made my position clear, my lord? I'll read that authority subsequently, my lord. Section 47 document would come, my lord. Here there is no section 47 document, my lord. Here what they have done, when a doubt arises in the Indian criminal justice delivery system, my lord, the benefit has to accrue to the accused, my lord. Can you see, my lord, at page 18, here grounds of arrest, my lord, in the arrest memo, it is not there, my lord. What they have done, only one line is there, my lord. Kindly see. It is chronologically 3, my lord. Leaving aside one line from the top, he has been explained the grounds of arrest. Have I made my position clear, my lord? Meaning thereby orally, my lord. Language speaks, my lord. He has been explained the grounds of arrest. He was also informed about his right to have someone informed about his arrest. That in writing, it is not there, my lord. Have I made my position clear, my lord? The language itself speaks, he has been explained the grounds of arrest, meaning thereby orally. There should have been 2 more words. They need not be economical with words, my lord. That in writing, it is not there, my lord. That I'm putting emphasis on it, my lord. Thereafter, down below, my lord. Kindly see how they clarify it subsequently. Because my signature was there, my lord. Now in a handwritten, I have written it, my lord. Received arrest memo and grounds of arrest. Have I made, meaning thereby this document, my lord. But they have explained in their affidavit that it was given in a separate annexure, my lord. Along with this, my lord. Have I made my position clear, my lord? Had it been so, it should have been written here, received grounds of arrest in a separate set of enclosures. Have I made my position clear, my lord? You do your job in a half-hearted manner, result is this, my lord. When the question mark arises, the language itself speaks that grounds of arrest were communicated to him orally, my lord. And thereafter, this line is written, my lord, that grounds of arrest, received arrest memo, and grounds of arrest. That in separate annexures, it is not there, although it is their stand in their affidavit. So, our case, my lord, benefits must accrue to the accused when there is a law, and this is not that the 47 document is missing, my lord. Arrest memo, because Code of Criminal Procedure is applicable, it is not a complete code in itself, the GST Act, my lord. Have I made my position clear? That ground we have also taken, that grounds of arrest have not been provided to us in writing, my lord. In writing, my lord. With all respect, my lord. Now I come to page 51, my lord. Kindly see, my lord. I'll read it conjointly, my lord. Now come to page 51, grounds of arrest. Grounds of arrest, my lord. There, kindly see, my lord, the DIN number is missing. Right hand on top, nowhere it is there, my lord. And these measures, my lord, have been taken, although, my lord, not codified in law. In future, it will be codified in law, my lord, so that human rights are not violated, my lord. Have I made my position clear, my lord? So I'll read that government notification, departmental, their own notification, and the Delhi High Court Authority. Here the DIN number is not there, my lord. Have I made my position clear, my lord? Here his signature was taken, my lord. Here his signature has been taken. But had it been so, they should have been more clear, my lord, in their stand that this is the annexure, my lord. Have I made my position, my lord? Clear, my lord? This is our case, my lord. And the DIN number is missing, my lord. Thereafter, my lord. Again, drawing a parallel, my lord, will have a look at page 19. Jama Talasi. So that everything is on equal footing, my lord. Jama Talasi, Lordship has seen, my lord. Page 19. There the DIN number is there, my lord.
Yes, I have.
DIN number is there, my lord. So, how can a department, my lord, hide and seek, my lord, in one document DIN number is there, in one document DIN number is not missing. Then the doubt arises, when a doubt, suspicion arises, benefit is to accrue to the accused, then it was created later hand, my lord. With all respect, my lord. And the notification itself speaks, my lord. Now I come to the notification of the department, my lord. Then I'll. And thereafter, my lord, with all respect, my lord, page 20 is also same. No DIN number, my lord. That my lord, relatives are to be informed. There it's a letter creation, my lord. DIN number is missing, my lord. Now regarding DIN number, my lord, page 53, my lord. We have annexed this the notification, my lord. Lordship, kindly make a note, my lord. GST, Government of India, Ministry of Finance. It's a Ministry of Finance, my lord, document occurs at page 53, my lord. Lordship has found, my lord. There I begin at para 2, my lord. The board in exercise of powers goes on and on, my lord. This embargo was placed on them that in every official document, DIN number has to be there. Then I come to page 54, para 3. Whereas a DIN is a mandatory requirement, in exceptional circumstances, communications may be issued without an auto-generated DIN. However, this exception is to be made only after recording the reasons. Have I made my position clear, my lord? In that document, that it should have been noted that why DIN number was not there. It is nowhere mentioned, my lord. Then the consequential effect is 5, my lord, with all respect, my lord. If there is no DIN number, then there has to be an explanation, my lord, with all respect, my lord. So that human rights are not violated, accused are safe, my lord. Have I made my position clear? My lord, now I read para 5. Any communication issued without an electronically generated DIN in the exigencies mentioned in para 2, if it is explained well and good. Have I made my position clear? Here there is no explanation above. Shall be regularized within 15 working days, each issuance by so and so, so and so, so and so. Have I made my position clear, my lord? 1, to obtaining the post. Then, my lord, I left out one paragraph so that I put emphasis on it, my lord. When there is no DIN number, the result is this. The board of 4, my lord, of the notification occurring at page 54, it has begun at page 53. The board also directs that any specified communication which does not bear the electronically generated DIN is not covered by the exceptions mentioned in para 3. Same is the case here, tailor-made, my lord. Shall be treated as invalid and shall be deemed to have never been issued. In so many words, in as many words, have I made my position clear, my lord? That document has no value. Important is, my lord, page 49. Most important document, my lord. Page 49, my lord. My lord, with all respect, my lord, page 49 is authorization of arrest, my lord. Very nice, no? Reason for this. My lord. Here, my lord, I am placing this one is the most important document because it has to show, my lord, with all respect, my lord. First of all, in GST, my lord, when somebody is picked up, arrested, detained, my lord, the reasons of arrest are to be formulated by the authorities concerned, my lord, who carry out the arrest. It is a prior job, my lord. It cannot be a subsequent job. Making up the mind, my lord, of the authority concerned, my lord. Here, my lord, reason to believe is missing. Now, my lord, reason to believe is missing, my lord. Now, my lord, it has not been given to us, my lord. Now, my lord, my friend will, he is very, of course, he has done his homework umpteen number of times, my lord. He quotes several high courts, my lord. Then the views were different, my lord. Now is settled now, my lord. It cannot be an internal document as has been stated in the affidavit. May I just read it, my lord? That is an exercise in nullity, my lord. Page 7, page 144 of their affidavit, my lord. Objection, my lord. Then I'll read the authority, my lord. My din high court to no call, high court to go like dinner. No call be more wisdom.
Page number 144.
My lord, page 144, my lord. There I read para 7. কমপ্লিট কোড নহয় বুলি যে কৈছে তুমি চিন্তা কৰিলে My lord, I'm sorry, my lord. Lordship, but kindly have a look first at 142. It is
142.
142. It is their admission that their language is little bit, my lord, it has gone haywire. It is stating, my lord, that the GST Act is a complete act in itself, meaning thereby it's a complete code in itself. Have I made my position clear, my lord? They have categorically stated at page 42, occurring at para 6. There is an exercise in nullity, nothing but the truth, apart from the truth, far away from the truth, my lord. The GST Act is a complete act in itself. Have I made my position clear, my lord? Page 69. And now, my lord, it cannot be, my lord. This is contrary to, my lord, with all respect, my lord, Radhika Agarwal, as has been reported in 2025 SCC online, SC 499. Para 50, my lord. Pleasure. I'll be very cryptic, my lord. Lordship finds para
50.
49, my lord, one paragraph higher, 2 line, my lord. We shall now draw our attention to the provisions of GST Act. It is in the comparison between, my lord, whether parametry or not, my lord, with Customs Act, my lord. I'll be very cryptic, my lord. 50. To a large extent, our reasoning and the ratio on the applicability of the code, meaning thereby the Code of Criminal Procedure at that point of time. Now, Bharatiya Nagarik Suraksha Samhita, my lord, of code to the Customs Act would equally apply to the GST Act in view of section 4 and 5 of the code. Full stop. No argument further, my lord. Quoting High Court's own do, my lord. Have I made my position clear, my lord? 2025 authority, to a large extent, our reasoning and the ratio on the applicability of the code to Customs Act would equally apply to GST Act in view of section 4 and 5 of the code. Have I made my position clear, my lord? So that it is a complete code in itself, GST code, is an exercise in nullity and is not truth, is not the truth. With all respect, my lord. Thereafter, last parting lines, my lord. We would therefore agree with the contention that the GST Act are not a complete code when it comes to provisions of charge, seizure, and arrest. Have I made my position clear, my lord? For the provisions of the code would equally apply when they are not expressly or impliedly excluded by provisions of the GST Act. Now they have opened the Pandora's box, my lord. 41A, with all respect, my lord, it relates to arrest, my lord. Have I made my position clear, my lord? So Apex Court has clarified, my lord. 41A is a must if somebody is to be arrested in a case wherein sections of the GST are attributed to it, my lord. Have I made my position clear? 3 things, my lord. I've been seeing too many things, my lord. I missed out on certain things, my lord. Let me first make it clear, my lord. Din I quoted, my lord. On din that authority, I'll read Delhi High Court, my lord. তাৰপিছতে কোনটো কৰিব লাগিব তাতে আৰু এটা কৰিব লাগিব পাবলিক ন দিনৰ পিছত কোনটো আছে ক্লিয়াৰ কৰিলে পাহৰি গৈছো ৰেটিংটো কৰি লওঁ দিনৰ কোনটো পেৰাগ্ৰাফ কন্টিনিউ My lord, with all respect, my lord, this is Delhi High Court, my lord. Kisitji Ghedial, Director General of GST Intelligence, Delhi. Delhi, my lord. There I come to para 44. There are also grounds of arrest were not provided, my lord. Para 44, my lord. Lordship has found para 44.
44, no?
44, my lord.
Yes.
44, my lord. Leaving aside, my lord. 1, 2, 3, 4, 8, 9, 10. Leaving aside 10th line from the top, my lord. Thereafter, I read, my lord, with all respect, my lord. CBIC circular dated 5/11/19. Lordship has found, my lord. That circular I read out, my lord. Just now I read that before your lordships, my lord. This is the circular dated so and so, my lord. Directed that no search, authorization, summons, or arrest memo even, my lord, shall be communicated, issued to a taxpayer or any other person without a computer generated DIN, which should be quoted prominently in the body of the communication, hosted on an online portal, so and so, having used the DIN on the first summons to elicit the generation time. Petitioner contends that the summons never existed at the time they were sub or at the time which was scheduled for the petitioner's appearance. This is argued would bear out the petitioner was detained illegally at the responsive office without summons, and the summons were generated subsequently. Have I made my position clear, my lord? Whatever documents annexed by me regarding search, seizure, and arrest, my lord, which does not contain a DIN number, as I have specified before your lordships, my lord, is no paper issued by the authority itself. Have I made my position clear, my lord? Their own notification and this authority, it may not be an Article 141 authority, my lord. When there is no 141 authority of the apex court, my lord, when there is no authority of our Honorable High Court, my lord, any other law laid down in India, my lord, would be part of the Indian criminal justice delivery system, so far as GST is concerned, my lord. With all respect, my lord. Now I read para 45, my lord. Strangely enough, at 21:58:35, 3 minutes after the first summons, I placed certain documents which did not carry the DIN number, my lord. Here the number should vary, my lord. The second DIN was then that goes on and on, my lord. This attempt, last parting lines, my lord, as per petitioner, of having detained petitioner without any paperwork, and the time creating the paperwork subsequent to cover up the tracks, my lord. Have I made my position clear, my lord? So I get benefit because it doesn't contain DIN number, my lord. Now, my lord, the reasons to believe, my lord. Reasons to believe, my lord. Thus, the authority must form an opinion. Reasons to believe, my lord, that somebody has to be picked up, arrested. Detention is subsequent, my lord. With all respect, my lord. Now, in their affidavit, they have said that is an exercise in nullity, not contrary, absolutely contrary to law, my lord. With all respect, in their affidavit at page 144, they have stated, my lord, with all respect, my lord, in para 7, it is in black and white, my lord. With having highest regards to the department also, my lord. However, in the para 7, last 4 lines, my lord. However, in the instant matter, authorization to arrest dated so and so issued by the additional director general is an internal document, and the same is not addressed to the taxpayer. Have I made my position clear? The whim and wishes of the department won't go. The law laid down and the law as is prevailing as regards GST would go, my lord. Because the authorization of arrest is to carry the reasons to believe part of the case in question, my lord, when somebody has been arrested. I'm sorry, my lord. With all respect, my lord. So, in that reasons to believe, my lord, authorization of arrest, my lord, it is nowhere there. Now I read para 145, page 145, para 7.1 of their document, my lord. My lord, 7.1, my lord. 7.1, my lord, with all respect, my lord. Last parting lines, my lord. The reasons to believe before authorizing the arrest of the petitioner has been recorded in the file. Have I made my question clear, my lord? Has been recorded in the file, not given to us, my lord. That should not be the procedure. Now I go to the authority concerned, my lord. Have I made my position clear, my lord? This has been explained in Radhika, my lord. May I, my lord? My lord, that it cannot be an internal document. Reasons to believe cannot be kept in the file without communicating it to the arrestee, my lord. That occurs at Radhika, my lord. 2025 SCC online SC 499, my lord. Para 31, my lord. Leaving aside, sorry. My lord, with all respect, my lord. Radhika Agarwal, that authority, my lord. I am reading para 31, my lord.
Para?
Para 31, my lord.
Yes.
My lord, para 31, I am reading the last, my lord, 1, 2, 3, 4, 5, last 6th line, my lord, from the top, my lord, in between. These safeguards include the requirement to have material in the possession of DOE, and on the basis of such material, the authorized officer must form an opinion, that, my lord, forming an opinion, my lord. Opinion and record in writing their reasons to believe that the present arrested was guilty of an offense punishable under the PMLA Act. The grounds of arrest are also required to be informed forthwith to the person arrested. Meaning thereby, the law says, Apex Court in Radhika, Article 141, that the reasons to believe that a person arrested was guilty of an offense punishable under PMLA Act. The grounds of arrest are also required to be informed forthwith to the arrested person. Meaning thereby, reasons to believe are to be provided to the arrest. It cannot be on file of the department without it being communicated to the arrestee, my lord. These lines again I reread, my lord. These safeguards include the requirement to have material in the possession of DOE, and on the basis of such material, the authorized officer must form an opinion and record in writing their reasons to believe that a person arrested was guilty of an offense punishable under the PMLA Act. The grounds of arrest are also required to be punished, meaning thereby reasons of belief are also to be provided to the arrestee. Have I made my position clear, my lord? With all respect, my lord, in as many words. Next paragraph is furthermore making it furthermore crystal clear, my lord. The contention of the DOE that while grounds of arrest were mandatorily required to be supplied to the arrestee, reasons to believe, being an internal and confidential document need not be disclosed, was decisively rejected in Arvind Kejriwal. Law has been reiterated in Radhika, my lord, that it must be communicated. There need not be another line that it is fatal to the prosecution case, my lord. The language itself, the ratio itself is clear enough, and it sends the message, my lord. And in their affidavit, they have taken a stand that it is in their file. Have I made my position clear, my lord? This contrary to whatever they have stated, that is contrary to law, and he deserves the benefit of bail, my lord. With all respect and full adherence, my lord. Now, my lord, in Vivan, this has been reiterated, my lord, possibly. Let me just place it, my lord. Okay. Now, my lord, Vihan has opened the floodgates, my lord. Just academic, my lord. Because in Probir Puruka, although it was a case under the Unlawful Activities Prevention Act, it contained the embargoes, my lord. Even then, it has to be further clarified by Vihan, my lord, that acts having embargoes, even then if, my lord, 47 is violated, 22(1) is violated, my lord, one has to be released on bail, despite, my lord, there being embargoes, my lord. Have I made my position clear, my lord? So Vihan clarifies another thing, just to believe me, regarding CRPC, my lord. I am reading para 19, last line, my lord, para 19 of Vihan, my lord.
Yes.
My lord, I am coming, my lord. This is reiteration, but anyway, my lord. Therefore, what we have held about section 50, court has held in Probir Purukayas and Vihan prior hand, my lord, that section 50 would be applicable at that time. Now 47 at the time of arrest, my lord. Have I made my position clear? Because here 47 document is missing, my lord. They write their own language. When the code is applicable at the time of arrest, my lord, with all respect, my lord, arrest memo cannot be prepared in a different manner, my lord. Have I made my position? Going further deeper into the equation, my lord, and the situation, my lord. With all respect, my lord, the 50 would be applicable. 50 document is nowhere there to be found, my lord. With all respect, my lord. This is a reiteration, my lord. Anyway, I have placed it, my lord. Huh? Judgment High Court to review, no? My lord, this authority should not have to repeat, my lord, possibly. Putting emphasis, my lord, that my lord, when it is based on, first of all, my lord, this case, quantum of punishment is extend to 5 years. It's not a huge heinous crime, my lord. Intention of the legislature was very clear. Let it be in billions, my lord. If evasion is proved, my lord, he'll be convicted, and conviction can be up to 5 years, my lord. So here, my lord, with all respect, my lord, 5-year period offense there. Sorry, my lord, 60-day period offense during investigation. No embargo is there in GST, my lord. That PP is to be hard. Then, my lord, so many things, my lord. Is a court is to form an opinion that he is guilty of such, he is not guilty of such offense. Those are missing, my lord. And the entire case is based on documentary evidence. I rely on a paragraph of the forwarding report of a co-accused, my lord, SARS accused, my lord. Then my role will be, I'm blind, my lord. Page 44. My lord, 44-hour bail application, my lord. I'm not saying that the petitioner before a lordship is blind. He is absolved of the offences. I'm not saying that, my lord. But what this paragraph says, my lord, that is their document, my lord. My lord, with all respect, my lord. On being shown is WhatsApp conversation. My lord, not my conversation, my lord. Who accused conversation, my lord. Sir will be representing, my lord. Item number 2, that document we have annexed, my lord. On the basis of, because he was found from my room, my lord. Have I made my position clear, my lord? On being shown his WhatsApp conversation from mobile number so and so with one Rahul, someone, my lord. He was asked about some ledgers exchange between them. He replied, he along with Sri Rahul Jadhav, Rahul Dongal, accountant of Sri Shubham Jain, used to operate, manage, control 6 other fake entities and details. Have I made my position clear, my lord? Definitely I am at fault. I may fall within a 120B, 5-year period offense, my lord. With all respect, my lord. I am not the character perpetrating everything, my lord. Perpetrators of everything, my lord. My accountant. Have I made my position clear, my lord? And I am already there for around 30 days, my lord. Oh. My lord, regarding, may I just draw? I'm sorry, my lord. May I?
If I may be taking there is a tribunal sitting in court number 4 at 3 p.m. I'll take 10 minutes. In the meantime, I'll will submit.
He'll reply.
Much.
Well, I'll be very quick, my lord. Lordship, may kindly have a look at page 20. This is, my lord. I'll be very quick, my lord. Here, this 20 document is very necessary, my lord, because law recurs, requirement of law now is, my lord, even family members are to be informed, my lord. This law will develop, my lord. He is blind, my lord. It is furthermore needed, my lord. Have I made my position clear, my lord? Here, there is no DIN number, my lord. That is to, I'm putting emphasis, my lord. There is no DIN number, my lord. Now, my lord, informing relatives, as has been held by Bihan, the latest authority, my lord. Latest authority, my lord. I am reading para 2 of the 2025 SCC online SC 269, Vihan Kumar versus State of Haryana and another that authority, my lord. There I am reading para 2, leaving aside judgment, my lord, and Koteshwar Singh, my lord, his part of the judgment, my lord. Leaving aside 12 lines from the top, I leave aside, my lord. Thereafter, I begin, my lord. It may also be noted, with all respect, my lord, it may also be noted that the aforesaid provisions of recommend for communication of the grounds of arrest to the arrestee, my lord, these are my words, my lord, and to the relatives, my lord, to be purposeful is also required to be communicated to the friends. It may not be there in the statute, my lord, section 47 document. Have I made my position clear, my lord? It also requires to be communicated to friends, my lord. So it's an article 141 authority, my lord. That requirement has been followed. But because of not containing a DIN number, it is an exercise in nullity, my lord. They have read the law, incorporated it to the best of their ability, and possibly it is fraudulent activity, my lord. Have I made my position clear, my lord? To be purposeful, it also requires to be communicated to the friends, relatives, or such other person of the accused as may be disclosed and nominated by the arrested person for the purpose of giving such information as provided under section 50A of the CRPC. As may be noted, this is in addition to the requirement as provided under section 51 of the CRPC. It is there also in the statute, my lord, that relatives are to be informed, my lord. If that requirement is missed out, it is an exercise in nullity, my lord. He deserves, my lord. In BNS, my lord, this is incorporated, my lord, 48. My lord. I'm reading 48 of BNSS, my lord. Every police officer, other arrest under Sanita shall forthwith give information regarding such arrest and place where the arrested person is being held to any of his relative, friends, or such other persons as may be disclosed or nominated by the arrested person. Only following 47 undo, my lord. Following 48, new incorporation beyond, my lord. 48 is a must, my lord. And in following 48, my lord, in a manner which is not applicable to the GST Act without containing DIN number is an exercise in nullity, my lord. On that count also, he deserves some benefit, my lord. Have I made my question clear, my lord? With all respect, my lord. Now, my lord, two affidavits we filed, my lord. Because regarding, my lord, blindness 100%, that official document and everything we have given, we have read out the magistrate's order that he was never taken by them, that the medical board should be set up that he is blind admitted. In the FIR itself, it is their case, my lord, that he is virtually impaired, my lord. So there cannot be a question mark on his physical disability, my lord, blindness, my lord, notwithstanding 76, my lord. And thereafter, my lord, I read the, my lord, with all respect, my lord, my lord, may I come to, my lord, with all respect, my lord, of the additional affidavit, page 36, my lord. I'm sorry, my lord. Page 76 is, my lord, is the death certificate of his wife, my lord, the blind man's wife, my lord. With all respect, my lord.
Is one?
Page 76, my lord.
76.
My lord, with all respect, my lord. First affidavit, my lord. দুখন এফিডেভিট আছে বাইদেউ page 76, my lord, is the death certificate that is dated, my lord, with all very recently, my lord, 24/2/2020, my lord. His wife's death certificate, my lord. At the time of COVID, she expired, unfortunately, my lord. And thereafter, 77, the birth certificate of one male child, Abhinav Jain, his child, my lord. There is none to look after. That the birth certificate is issued on 6/2/2019, my lord. Kid, my lord. And the second child, that is at page 78, my lord. That he is also, my lord, a minor, with all respect, my lord. My lord, the date of birth is 23/2/20, my lord. And the first birth certificate is the date of birth is, my lord, still a minor, my lord, with all respect, my lord. The date of birth is, my lord, 2/2/2019, my lord. One is 19 born, my lord. The other is, my lord, page 77 is 19 born, 78 is 2020 born, my lord, date of birth, my lord. And the others are school documents, may not be necessary, my lord. Preschool or whatever be it, my lord. And the second affidavit, my lord, with all respect, my lord. Several orders we have annexed. My lord, it begins at page 86. This is the case, my lord. No physical disability, my lord. May I read, my lord? Page 86 is, at para 9 it appears, there the Alice defalcation of GST is 15 crore. Almost similar, my lord. Here we come 14 crore plus, my lord. Page 86, it begins, my lord, and in para 9 of this order, para 9 I am reading out, my lord. Paragraph 9, my lord. It has Lordship has found, my lord, with all respect, my lord. It has also come out from materials on record that a state GST Assam conducted it so and so, so and so, so and so, goes on and on, my lord. Thereafter, next page, my lord. The petitioner had evaded GST 15 crore, 59 lakhs plus, my lord. Our case is also, my lord, with all respect, my lord, 14 crore plus, my lord, as if we have evaded, my lord, as we may have evaded, my lord, with all respect, my lord. And here he was in custody, my lord, with all respect, my lord. 30 days, my lord. 30 days, you, I mean, no, the custody. I mean, 28 days, my lord. 30 days, my lord. With blindness, my lord, with all respect, my lord. This is one authority. There is another authority at page 101. Here it is 9 crore, my lord. That occurs at, if I read para 13, 21, and 22, my lord, and para 27, here is the quantum involved is 9 crore and my lord, 28 days, exactly same number of days, my lord. Different case, my lord, granted the privilege of bail, GST evasion, around 10 crores, my lord, 9.11 crore, my lord, with all respect, my lord, and he was in custody while he was granted bail. He was there for 28 days, my lord. Page 114, my lord. Here the my lord, quantum of evasion is 10.29 crore, 10.29 crore. Here he was in custody only for 15 days, my lord. Interim was granted, my lord. Next continuing, and the next date fixed is on 8th, my lord. And my lord, definitely this order will be passed on that day. It has been charge seated, my lord. He will appear and go on bail, my lord. He was there in custody for 15 days, and the quantum of evasion was around 10 crore plus, my lord. And another annexer we have, and this was granted, my lord, not in a bail application, by way of a writ application, because writ is also applicable, my lord. This is one order, and another order that occurs at Sessions order is also there, my lord. Session court granted bail. Page 123, my lord. 123 and 127, given quantum. Here also, my lord, around, my lord, 25 crores. Here the bail has been granted for violation of 41A, my lord. Have I made my question clear, my lord? Because of 41A and period of detention, my lord. My lord, I don't know, my lord. And another order, my lord, with all respect, my lord.
127.
Page 127. They are also granted the privilege of bail. There also the defalcation is, my lord, have passed on intellectual effect to the tune of 51.39 crores, my lord. That occurs at 127. And because of violation of, my lord, with all respect, my lord, 41A, bail has been granted by the learned court below. These are orders we have placed, my lord, primarily on the count, my lord, with all respect, my lord. Computer details. Here there is, my lord, violation of 41 is apparent. Grounds of arrest provided, not provided, without DIN number, apparent, my lord, with all respect, my lord. Afterthought, as per us, my lord, with all respect, my lord. And my lord, with all respect, my lord, blindness is complete, my lord, on human fear gun. If possible, my lord, he deserves some benefit, my lord. And my lord, on the top of it, my lord, even in a case of heinous offense, earlier it was 437, my lord. A magistrate is not supposed to release a man accused of committing an offense under section 302 IPC. As an example, my lord. But he can. He could at that point of time, my lord, while during existence of 437, now the same is replicated, duplicated, my lord, with all respect, my lord. So far as 480 is concerned, my lord. If somebody is sick, infirm, and minor, my lord, I'm just reading out that part, my lord. 480, now 480, my lord, earlier 437, provided that a court may direct that a person referred to in clause 1. Such a person shall not be released. Clause 1, I am reading out of 480, my lord. Such a person shall not be released if there appear reasonable grounds for believing that he has been guilty of an offense punishable with death or imprisonment for life. Even in those offenses, at the magisterial level, with all respect, my lord, one can be enlarged on bail, provided the court may direct that a such person referred in clause 1 or clause 2 can be released on bail if such person is child or is a woman or is sick or infirm. Here absolutely infirm person, my lord. Even that power is vested in a learned magistrate, my lord. Now, my lord, we have come up before your lordships, my lord, on the ground of illness. Possibly he deserves some benefit, my lord. With all respect, my lord. And my lord, I need not have to go to Kavita and all those authorities are there, my lord. It reiterates, my lord, everything, my lord, regarding sickness and everything, my lord. With all respect, my lord.
Almost everything is covered, my lord. Only the difference is blindness. I am not blind, my lord. Fortunately, my lord. Now, in my case, my lord, 132. Now, just my lord, I take to your lordship to section arranged, my lord, in this case, 132, my lord. 5 punishment. Asana ki, Goods. Allegation on my lord, issuance of fake, my lord, invoice without supply of goods. This is whole substance allegation, my lord. Now, your 132, your lordship will have a punishment for certain offenses. Now, your lordship will find, your lordship got it one. 132.
Yes.
Yes. Now, 132 subclause 5 minus now 132 minus whoever commits any of the following offense, namely. So I am not all my lord. B, let us come to B, my lord, here. As per FIR now. Issues any invoice, your lordship got it, man, or bill without supply of goods or services or both in violation of the provisions of this act, or the rules made thereunder leading to wrongful availment or utilization of input tax credit or so and so. Then I kindly come to next one, shall be punishable. Page, shall be punishable. Next page, my lord. Yes. But shall be punishable, shall be punishable in case of I fall under number 1. So Roman 1. In case where the amount of tax evaded or amount of input tax credit wrongly availed or utilized or the amount refund wrongly taken exceeds 500 lakh rupees with imprisonment for a term which may extend to 5 years and with fine. So this is the, suppose if the, my lord, assuming that the allegation is correct, I fall under this, my lord. 5 years, my lord. Already, my lord, 28 days today, my lord. I'm arrested on 7/3/25. In addition to the point of law, my lord, and friend has already placed, I also adopted, other than that blindness, my lord. And my question is, my lord, everything is, my lord, what is the allegation? The fake invoice without supply of the goods. Everything, my lord, already seized. Everything recovered. Now, whole case now depends on the documentary evidences. My further custody, I am only on that, my lord. My further custody is given up 60 days is the, my lord, the statutory period, my lord. And my learned friend has placed so many judgment, my lord, that 1 month, 31 days, 32 days already he has placed. And documentary evidence, my lord, I have also some judgment I am giving to your lord, just for your lordship. I should not take much time already, my lord. Your lordship, other friends are waiting, my lord. Basic question, my lord, here. That, my lord, 28 days today, my lord. Everything on documentary evidence, there are ample of judgment, my lord. Or your lordship was pleased to consider take the period of detention, my lord. I'm not saying, my lord, I am saying I have nothing I have done. Assuming I have done it, my lord, at this moment, my lord, for the sake of argument, my lord. Then my further detention is not required. This is my humble submission. Police custody also not, they have not sought for. But they can not say everything seized, my. So that they have interrogated in the jail also, my. Twice, my. So on the face of this matter, whether the further custody is required, detention required, that is your lordship can decide. And documentary evidence, my true judgment and just your lordship. One is my 2024 SCC online, 1920 page, my lord. Your lordship will find in paragraph 55, 56, 57. 57, let us see, my lord, short paragraph, my lord. Your lordship will get it, my lord. In so, 55, 57.
55.
51st, let us ask, as observed by this court in case of Udikanti Nasimulia Supra, the objective to keep a person, my lord. The objective 55, my lord, paragraph 55. The objective to keep a person in judicial custody pending trial or disposal of an appeal is to secure the attendance of the prisoner at the trial. They have never stated in any of the grounds that I shall evade it, but I'll plead away that nothing is there, my lord. Then in the present case, the appellant is having deep roots in the society. There is no possibility of him fleeing away from the country and not being available for tracing. I have been asked to appear, my lord, I appear. And on my appearance, they have taken to my custody, my lord. So I have never defaulted, my lord. They asked me to appear, I have appeared, my lord. Then 57, last paragraph, my lord. In so far as the apprehension given by the learned Additional Solicitor General regarding the possibility of tempering the evidence is concerned, it is to be noted that the case largely depends on documentary evidence which is already seized by the prosecution. As such, there is no possibility of tampering with that evidence. In so far as the concern with regard to the influencing witness is concerned, the said concern can be addressed by imposing stringent conditions. That is enough, my lord. I think, my lord, this may also be, my lord, for the purpose of bail, I think your lordship may consider, my lord. And the rest thing about the ground of arrest 47, 48, my learned friend, my lord, 48 is must, my lord. 48, nothing is there in the 48, nothing. My lord. Assuming the 47 they have given, although we dispute on that part of it, the way how it ought to have been given, not given, my lord. But 48, nothing. That is very important, this, my lord. 48 is nothing.
41 is there,
And 41 also not given. 41 is also. So, my lord, on the face of this matter, I think further custody is not required. My lord. That is. I want the documentary evidence, my lord. Further, for what purpose they will retain me there, my lord. Only for interrogation, the other things. And tampering, I have fully cooperated, my lord. Before taking to my custody, I cooperated. I have responded to their call. The day I have not taken even time also, my lord. The time which they have given, I have attended on that day. Thereafter, I will obliged to us.
This is on next, vote number 4 in tribunal matter, lordship.
But if other matters, this one here has come already.
Lordship, many argument has been made by my learned senior friends that many defects has been committed by the GST authority while arresting. Lordship, coming directly to the judgment passed by the Honorable Supreme Court in Radhika Agrawal. Is paragraph 49 onward. My learned senior has read out few sentences from judgments. Probably there are two parts of this into judgment. First was considered with respect to custom and another for GST. Lordship, I want to read from paragraph 49. Here in this case, Lordship, the provision of section 69 was challenged before the Honorable Supreme Court in different writ petitions. And ultimately, Honorable Supreme Court upheld the provision of section 69. While dealing with this, Lordship, Lordship, for the benefit of all the parties, probably we have to read all the paragraphs for benefit of me also. Paragraph 49. We shall now draw our attention to the provision of GST Act. We have collectively referred to the central as well as the state GST as GST Acts. Paragraph 50. To large extent, our reasoning and ratio on the acceptability of the code to the Custom Act would equally apply to the GST Act in view of section 4 and 5 of the code. Subsection 10 to section 67 of the GST Act postulates that the provision of this code related to search and seizure shall, as far as may be applied to search and seizure under GST Act, subject to the modifications that for the purpose of subsection 5 to section 165 of the code would magistrate shall be substituted with the word of commissioner. Section 69, which deals with the power of arrest. A provision which will refer to subsequently also deal with the provision of the code when the persons arrested by offense under GST Act is produced before the magistrate. It is also dealt with the powers to authorize officers to release or arrest a person on bail in case non-bailable and bailable offense, having the same power and subject the same provision as applicable to the officer in charge of the police station. We would therefore agree that the content of the GST Act are not a complete code when it comes to the provision of search and seizure and arrest, but the provision of the code would equally apply when they are not expressly or impliedly excluded by provision of the GST Act. Paragraph 51. There is no specific stipulation or provision in the GST Act in respect of facets of investigation, inquiry or trial. This court in Ashok Monilal Jain and another versus so-and-so reported in so-and-so held that in view of section 4(2) of the code, the procedure prescribed under the code also applies to the special statutes unless the applicability in expressly barred or prohibited. The provision of GST Act in this regard can contrast with the Railway Property Unlawful Act 1966. However, in our opinion, this does not help assist the petitioner's contention. Section 69 of the Act states that where commissioner has reason to believe that a person has committed any offense specified in clause A to D of subsection 1 to section 132, which is punishable under clause A to 2 or 2 of subsection 1 or subsection 2 of the said section, he may authorize any officer of central or state tax to arrest such person. Subsection 2 requires that when a person is arrested for an offense specified in subsection 5 to section 132, the officer authorized to arrest must inform the persons the ground of arrest and produce him before the magistrate within 24 hours. Then 132 has been explained. Let's see if we can speak. Then paragraph 54. Subsection 1 to section 132 consists of as many as 9 clauses in form of clause A to 1. Offenses under the said clauses are then graded in clause 1 and 2, depending upon the amount of the tax evaded, the amount of tax wrongly availed or utilized, or amount refund wrongly taken. In case of 1, when the amount exceeds 500 lakhs, the punishment may extend to imprisonment 5 years with fine. When the amount is less than 500 lakhs but exceed 200 lakhs, the punishment may extend to imprisonment for 3 years and with fine. When the amount is tax is less than 200 lakhs but exceed 100 lakhs, the punishment may extend to imprisonment for 1 year with fine. Clause 4 to section 132(1) deals with where the accused commits or abates the commission of an offense specified in clause F and provides a punishment which may extend to imprisonment of 6 months with or without fine. Under subsection 2 to section 132 deals with repeat offenders. Subsection 3 to section 132 requires that the minimum term of the imprisonment for offense under section 1 to 3 of subsection 1 of subsection 2 in the absence of special and adequate reason to the contrary to be recorded by the court shall be less than 6 months. Paragraph 55. Subsection 4 to section 132, an important provision for our consideration states that the notwithstanding anything in the code, all offenses under GST Act except the offenses referred to in subsection 5 are cognizable and bailable. Thus, the non-cognizable offense have been made bailable under subsection 4 to section 32 has to be read in light of the dictum of the Om Prakash Supra, which decision the legislature is fully aware and conscious of when they enacted GST Act. This is also clear from subsection 5 to section 132, which states that the offenses specified under clause A to D of subsection 1 of section 132 and punishable under under clause 1 of the subsection are cognizable and non-bailable. Thus, only when the offense falls under the limited category specified in clause A to D of section 1 of section 132 and when the amount of tax evaded amounts to input tax credit wrongly availed or utilized, or amount of refund wrongly taken exceed 500 lakhs, then the offense is non-bailable and cognizable. At this stage, we must note that the submission made on behalf of the revenue that in case the bailable and non-bailable offense, the central state offense do not make arrest. Arrests are made only when the offense is non-bailable and cognizable, satisfying the condition of subsection 5 to section 132 as specified in clause A to D of subsection 1 to section 132 of the GST Act. It is clear from the aforesaid provision that to pass an order of arrest in case of cognizable and non-cognizable offense, the commissioner must satisfactorily show what the reasons to believe recorded by him that the persons to be arrested has committed a non-bailable offense, and the preconditions of section 5 to section 132 of the Act are satisfied. Failure to do so would result in illegal arrest. With regard to the submission made on behalf of the revenue that the arrests are not made in case of bailable offense, in our considered view, the commissioner, while recording the reasons to believe, should state his satisfaction and refer to the materials forming the basis of his finding regarding commission of a non-bailable offense specified in clause A to D of subsection 1 to section 132. The computation of the tax involved in terms of the monetary limit under clause 1 of subsection 1, which makes the offense cognizable and non-bailable, should be supported by referring to the relevant and sufficient materials. Paragraph 57. The aforesaid exercise should be undertaken in right earnest and objectively, and not in mere dictic without foundational reasoning and materials. The arrest must be proceeded on the belief supported by reasons relying on materials that the conditions specified in subsection 5 of section 132 are satisfied, and not on suspicion alone. An arrest cannot be made on mere investigation whether the conditions are being met. The arrest is to be made on the formulation of opinion of the commissioner, which is to be duly recorded in the reasons to believe. The reasons to believe must be based on evidence establishing to the satisfaction of the commissioner that the requirement of subsection 5 to section 132 Act are met. Our attention was drawn in the judgment of the High Court of Delhi in McTree India Limited Private Limited reported in so, which is a decision interpreting the power of arrest under Finance Act 1994. These provisions are related to service tax, excise duty, service tax, and other taxes are subsumed under GST regime. Accordingly, we are in agreement with the finding recorded in the decision to the extent the power of arrest should be used with great circumspection and not casually. Further, as in case of service tax, the power of arrest is not to be used on mere suspicion and doubt or the even investigation when the condition of subsection 5 to section 132 Act are not satisfied. However, relying upon the judgment of the McTree, it has to be submitted on the behalf of the petitioner that the power under section 5 of section 132 cannot be exercised unless the procedure under section 73 Act is completed and assessment order is passed, qualifying the tax evaded and erroneous refund or input credit wrongly evaded. Accordingly, according to us, this contention should not be accepted as a general or broad proposition. We would accept that normally the assessment proceedings would quantify the amount to be tax evaded and go to show whether there is any violation in terms of section A to D of subsection 1 to section 132 of the GST Act. And in clause 1 to subsection 1 is attracted, but there should be cases where even without formal order of assessment, the Department Revenue is certain that that is the case of offense under clause A to D of subsection 1 to section 132, and amount of tax evaded, etc., falls within clause 1 to subsection 1 of section 132 of the GST Act with significant degree and certainty. In such cases, the commissioner may authorize arrest when he is able to ascertain the reasons to believe. As indicated above, the reasons to believe must be explicit and refer to materials and evidence underlying such opinion. There is to be degree of certain to establish that the offense is committed and the offense is non-bailable. The principle of benefit of doubt would equally be applicable and should not be ignored either by the commissioner or by the magistrate when the accused is produced before magistrate. The finding and the ratio recorded in paragraph 3247 of the above reference to Custom Act would equally apply insofar as maintenance of record as well as obligation of arresting officers and right of accused persons arrested are concerned. Compliance in this regard must be made. Section 61, the Central Board of Direct Tax has accepted the position by circular dated so and so. But see also it is important. I'm reading the main part of the circular. Honorable Supreme Court in case of judgment dated so and so, as observed, we may note that personal liberty is an important aspect. Our constitutional mandate, the occasion to arrest an accused during the investigation arises custodial investigation become necessary or is heinous crime or where there is possibility of influencing the witnesses or accused may abscond merely because an arrest can be made because it is lawful does not mandate the arrest must be made. A distinction must be made between the existence of the power of arrest and justification of exercise of it. If arrest is made routine, it can be cause incalculable harm to the reputation and self-esteem of a person. If the investigation officer has no reason to believe that the accused will abscond or disobey summons and has fact throughout cooperated with the investigation, fails to appreciate why there should be a computation of the on the officer to arrest the accused. Condition precedent to arrest. This is the internal circular that was accepted by the Honorable Supreme Court. Paragraph 3.1. Subsection 1 of Section 132 deals with punishment of for offence specified in subsection 1 of Section 69 gives the power to the commissioner to arrest a person who has reason to believe that the alleged offence has committed an offence specified in clause A or clause B or clause C or clause D of subsection 1 of Section 132, which is punishable under clause 1 or clause 2 of subsection 1 of subsection 2 of the Section 132 of GST Act 2017. Therefore, before placing the person under arrest, the legal requirement must fulfill the reason to believe. To arrive at decision to place a alleged offender under arrest must be unambiguous and amply clear. The reason to believe must be based on credible materials. 3.2. Since arrest impinges the personal liberty of an individual, the power to arrest must be exercised carefully. The arrest should be made in routine and mechanical manner. There should not be made in a routine or mechanical manner. Even if all the legal conditions precedent to arrest mentioned in 132 of the GST Act are fulfilled, that will not ipso facto mean that the arrest must be made. Once the legal ingredients of the offence are made out, the commissioner or the competent authorities must then determine if the person or if the answer to any of the some of the following question is in affirmative. Whether a person was concerned is then non-valuable offence or credible information has been received or reasonable suspicion exists.
So these are the conditions
These
for
are the conditions for the department. Then let's may come to paragraph 62. Thus, all precaution has been taken by that authority while making arrest. Let's see if it will clarify. And the challenge to section 16 was upheld by the Honorable Supreme Court subsequently. And in the one of the observation made by another judge, that is also important to be taken note by because many submission has been made that this defect has been committed by the department while making arrest.
I'll reply, ma'am. Let us go by the ratio, not by the obiter.
Yes, I'm reading lots of it is important to clarify everything. All points have been taken into consideration by the Honorable Supreme Court. Then paragraph 62.
Everything is there in para 60, my lord.
Yes, I've
That's
already read out.
It is, I'll not do it.
The circular also refer to the procedure of arrest and the principal commissioner, public commissioner has to record on file. Lots of this is also important. After considering the nature of the offence, the role of the person involved, the evidence available, and the reasons to believe that the person has committed an offence as mentioned in section 132 of the Act, the provision of the code, there be section 69(3) of the Act relating to arrest and procedure thereof must be adhered to. Compliance must also be made with direction of the DK Basu Supra. The format of arrest as prescribed by the Central Board of Indirect Taxes and Custom in Circular 128 so has also been referred to in this instruction. Therefore, the arrest memo should be indicate the relevant section of GST Act and others. In addition to the ground of the arrest must be explained to the persons and noted in the arrest memo. The instructions regarding ground of arrest came to be amended by the Central Board of Indirect Taxes investigation in 1 of 2025. The circular dated 13/1/2025 now mandates that the ground of arrest must be explained to the arrested person and also to be furnished to him in writing as an annexure to the arrest memo. The acknowledgement of the same should be taken from the arrested person at the time of service of the arrest memo. Instruction 2 of 2023 dated 17/8/2022 further lays down that the person nominated or authorized by the arrested person should be informed immediately. And this fact must be recorded in the arrest memo. The date and time of the arrest memo also be mentioned in the arrest memo. Lastly, a copy of the arrest memo should be given to the persons arrested under proper acknowledgement. The circular also make other directions concerning the material examination, the duty to take reasonable care of the health and safety of the arrested person and the procedure of arresting a woman, etc. It is also laid down that the post-arrest formalities which is to be completed with it further stated that effort should be made to file a prosecution complaint under section 132 of the Act at earliest and preferably within 60 days of arrest, where no bail is granted. Even otherwise, the complaint should be filed within a definite time frame. A report of arrest must be maintained and submitted as provided in paragraph 6.1 of the instruction. The aforesaid direction in the circular instruction should be read along with the specific direction outlined in the earlier judgment of this court and present judgment. Once the assertion of the allegations made on behalf of the petitioner is that the parties are compelled or coerced to make the payment of the tax in view of the arrest, this is in spite of the fact that no assessment or adjustment or adjudication as to the alleged demand. In this regard, we may refer to circular dated so issued by the Board of Indirect Taxes and Custom, referring to taxpayers depositing RCR or full tax liability during the course of such an inspection. This relevant access, which I am not going to read. Lordship, then the table has been annexed as per the direction of the Honorable Supreme Court. All provision has been taken into consideration. Lordship, then may come to paragraph 67. Analyzing the aforesaid data indicates that the number of persons arrested is normally in 100 or more. The data reflects that the number of arrests is invariably proportional to the percentage of amount recovered against the amount detected. That is upon when payment are made, the power of arrest is not being exercised. Further, the amount classified as the detection amount not to be amounted ascertained through assessment adjudication, but an amount quantified by the department authority connecting search and seizure. However, it is to be noted that the figure with regard to the tax demand and the tax collected would be in fact indicate some force in the petitioner's submission that the assessees are compelled to pay tax as condition for not being arrested. Under subsection 5 of section 74 of the GST Act gives an option to the assessee and does not confer any right on the authorities to compel or restrict any retaining arrest. This would be unacceptable and violative of the rule of law.
These are the things I can understand. So they have brought with some points or raised some issues in that regard regarding the grounds or reasons of arrest. All these things are there, and apart from the other issues raised by Mr. Mahadan. So in that context, this is the case I can understand that the procedurally what has to be followed as per you, those procedures are already followed. And that apart, yes, you are mainly stretching on this judgment on which point?
Entire case has been, because in this case, what happened? The provision of arrest was challenged before the Supreme Court. As many as 150 returns were filed. While answering this lordship, the Honorable Supreme Court says that the provision of section 6 power of arrest is valid under the constitution.
Hmm.
While making this lordship, I am coming directly to paragraph because the provision has been upheld. Probably there is no dispute with regard to my land and also not dispute.
Support
The-
is very correct, my lord. Whatever I respect his authority. What I am on, my lord, because nobody, he is correct, my lord. Arrest can be made to have been arrested. We are only seeking bail, my lord. We are not saying that arrest need be nullified. What is the, my lord? In one paragraph sums up this authority, my lord. Para 60. Whether, my lord, my friend should reply whether 41A is not applicable in GST. What the apex court has said. Have I made my position clear, my lord? Should I read that paragraph again, my lord? That 41A is applicable. I have never said that arrest is without following the due process of law. No, that is not our case. We are seeking bail. 41A is applicable in GST as has been established by the judgment in para 32, my lord. Have I made my position clear? And the ratio is in para 60 of this authority, my lord, wherein it has been stated, my lord, two-liner, my lord. Let us not go by the obiter. And if I read some lines that they arrest to, my lord, extract money. These are, my lord, obiters, not ratio. Ratio is contained in para 60. May I just read it? Make it quite thick, my lord. What para? First of all, my lord, with all respect, my lord, let him answer on 2 points. Reasons of belief, they have stated, they have stated it is a complete code by itself. GST Act. Yes or no? Ask him. He is to answer. Secondly, reasons of belief, reasons to believe, that is the language, my lord, technical time. Reasons to believe, my lord, whether it is to be kept in the file of the department or to be communicated to the accused, my lord. Have I made my position clear? This law has clearly stated, my lord, it is to be communicated to the accused. And that is, my lord, with all respect, my lord. Should I read it, my lord? I don't think so. These 2 points are to be nullified. 41A is a must. Here 41A has not been complied with. I deserve the benefit. There's a law in India. This authority, no matter reading the, my lord, obiter, ratio says it is applicable. It is not a complete code. As regard arrest, detention, seizure, my lord, 41A would be applicable. Then, my lord, providing the grounds of arrest in proper form, in writing, the language speaks editorially. Have I made my position clear, my lord? When 47 is there, 48 is there, can the department has an authority? Is it above the constitution? Article 22(1) and article section, then my lord, intention of the legislature, section 48 and 48. Can it give it in different set of papers so that they take signatures in white papers? That is the practice, my lord. They'll write it down subsequently. Have I made it clear or not, my lord? So why, my lord, 47 has been incorporated? And it is to be given in section 47. Law tells you to eat like this. You are to eat like this. You cannot eat like this. Have I made my position clear, my lord? Because at the time of arrest, let me list those 2 lines, my lord. I should not have read. My lord, may I come to para 32? With all respect, my lord. Let him deny it, my lord. No, 32, no. Sorry. Section 50, my lord. Section 50, my lord. My lord, the last parting lines, my lord. Kindly see. Para 50, my lord. Last lines, my lord. We would therefore agree. This is the ratio, my lord. We would therefore agree with the contention that the GST are not a complete code when it comes to the provisions of. Have I made my position clear, my lord? It is their avertment that it is a complete code. No, it is not a complete code as regards search, seizure, arrest. Have I made my position? Is it not a case of arrest, my lord? Arrest for the provisions of the code would equally apply when they are not expressly or impliedly excluded by provisions of the GST. 41A is as regards arrest, it is applicable. It has not been exclusively excluded by the GST Act. So 41A is applicable. When there is denial of 41A, I have annexed many authorities of coordinate benches, my lord. Then, my lord, with all respect, my lord, until an Ernest Kumar would follow, my lord. Secondly, my lord, reasons to believe whether to be communicated or not. They are affidavit, it is in the file. They are not to communicate. Should I read the paragraph, my lord?
Okay.
Not necessary. Now let me come to the authority, this authority, my lord, the ratio, what it says that it is to be communicated. Para 32, my lord. With all respect, my lord. Let me be clear, my lord. This is the ratio. Reading the obiter only, I'll read some obiter, which gives, my lord, the impression that a department arrests so as to coerce the money. That should not be done. But that is obiter, my lord. I am not reading it out. I am not to read the whole, my lord. I am to read the ratio. After all, court's time, my lord. In 32, what it says, my lord, I'll have to read it to make it 300. I think in Smith, but my lord, I dream in, my lord, whatever is the law is, my lord, I'll have to do like that, my lord. It cannot be otherwise. Para 32, what it says, my lord. The contention of the DOE stands for Department, whatever be it, my lord, that while grounds of arrest were mandatorily required to be supplied, this has got in consonance, my lord. That is why I am reading, my lord. Supplied to the arrestee. Reasons to believe, my lord, in their affidavit, it is in the file not to be communicated. What the law says, when the section is not incorporated in the statute, in the BNSS, Article 141 would be there, my lord. Law laid down by the Supreme Court would be applicable to all courts throughout the territory of India. What it says, my lord, this is the law. Reasons to believe, being an internal and confidential document, need not be disclosed. It is already decided, it was already decided in, my lord, that Delhi ex-Delhi Chief Minister's case, my lord. Disclosed, was decisively rejected by Arvind Kejriwal. Have I supra? Meaning thereby, because reasons to believe, sorry, my lord. Again, I'm, my lord, technical term, my lord, with reasons to believe, my lord. As they have said, it is there in the file, that won't do. It is to be communicated. Law is made clear under Article 141 in Arvind Kejriwal. And this authority has quoted Arvind Kejriwal. Otherwise, it would have been pari curiam, my lord. Am I correct?
Okay.
So on these points, if he disagrees that 41A is not necessary, let him say, this authority says this. Then let him say that reasons to believe are not to be communicated. Then let him say that circular, the circular by which DIN number is to be there in every official document, my lord. Has it been made ultra vires the Constitution of India by this authority? No. Am I correct, my lord? So that circular remains, meaning thereby any, my lord, authoritative document of the department must carry a DIN number. Otherwise, grounds of arrest were not communicated to us, my lord. And the first paper I read, my lord, therein it is clear, my lord, as if they had read it orally, my lord. Have I made my position clear, my lord? On 3 counts, on technical grounds, we deserve some benefit, my lord, with all respect. And my lord, if I am to read that how arrest is to be made, let me read it, my lord.
No, it's okay.
Sure. Let me read it, my lord. That arrest is there. They arrest to extort money, my lord. The apex court saying, my lord. I kept mum. Now I am opening my mouth. He said I read that I read part of it. My lord, I don't read part of it because of the reason if I read the whole, my lord, heavens will fall, my lord.
No.
Luckily he thinks in Hindi, my lord, dreams in English. I also dream in think in Assamese, my lord, dream in English. The law. But I placed it only the ratio, my lord, not the obiter.
It's okay.
It should come out before this number court. If there is an extraction by the department, Supreme Court taken care of this also, Lordship. That's why I have read out all these things. Only reading between 2 lines will not do.
No. It is dangerous, my lord. I never read between 2 lines.
And Lordship, regarding reason to believe, the Arvind Kejriwal has been taken into consideration. There is other discussion to that effect also. That should be placed before your Lordship.
But what is the law? The ratio is to be placed before the Lordship.
Yes, Lordship.
Then, my lord, let him define, my lord, that Arvind Kejriwal is bad law. Where it is said, let him read it.
No, Lordship.
Let me learn.
Lordship, it is there in the judgment itself.
Let him read.
In subsequent paragraph. Regarding first file address and mentioning the DIN number. Lordship, I read out the paragraph that the arrest memo should be an answer to the that the ground of arrest should be an answer to the censure. It is not necessary to mention the DIN number in all other documents. It is there.
In sound documents, DIN number is not there. As per
On
the-
arrest, only in arrest, ground of arrest, it is not there. In all other documents, it is there. It is admitted by my learned also.
Correct. My lord, ground of arrest is a vital document, my lord. And that has to be, should have been in 47 form, my lord. Because regarding arrest, section 47 is applicable, my lord.
Now, Lordship.
As Apex Court has said, man, that is the ratio.
Lordship, now, Lordship, come to section 70, then I'll place section 41.
Section 70 of GST Act law. Power to summon persons to give evidence and produce document.
Section
this-
17.
Yes. The power, the proper officer under this act shall have power to summon any person whose attendance he considered necessary either to give evidence or to produce documents or any other things in any inquiry or in the same manner as provided in case of civil code under provision of Code of Civil Procedure 1908 A1. All the persons summoned under subsection 1 shall be bound to attend either in person or by authorized person, a representative, as the officer may direct, and persons so appearing shall state the truth during the examination and make statement of or produce the document and other things as may be required. Then 2. Every such inquiry referred on subsection 1 shall be deemed to be judicial proceeding within the meaning of section 193 of section 228 of the Indian Penal Code. Now let's see section 41 of the CRPC. A. Notice of appearance before the police officer. The police officer shall, in all cases where the arrest of person is not required under provision of subsection 1 of section 41, issue notice directing the persons against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he committed a cognizable offense to appear before him or as such other place as may be specified in the notice. Where notice issued to any person shall be in duty of that person to comply with the terms of the notice. Then 3. Where such persons complies and continues to comply with the notice, he shall not be arrested in respect of the offense referred to in notice unless for reasons to record it. The police officer is the opinion that he ought to be arrested. So this is the section, and the similar provision has been made in section 70. What he appeared before the authority, and reason to believe was recorded by the commissioner in his file, that is I clicked before a lordship. Then he was arrest was made, arrest memo was issued to him along with the ground of arrest. Yes, it is correct that in arrest ground of arrest, DIN number is not mentioned. That was the annexure, and this is fortified by the annexure. Lordship page 18. Arrest memo. Page 18.
Yes.
Handwritten part. It is received by Suvan Jain, received arrest memo and ground of arrest. Date is mentioned, time is mentioned. Now lordship arrest memo. It is also annexed by the petitioner. Page probably 49. The ground of arrest is 51. Is dated 7/3/2021 25, and it was received by the accused person by the petitioner. It is written in the below of page 51. Yes, it is correct. DIN number is not mentioned. So in my humble submission, lordship, it is a annexure to arrest memo. In all other documents, lordship, DIN number is mentioned.
Put my DIN number to this.
But if one probably my learned friend is not committed in 69, there is a mention of commissioner, and the arrest, the reason to believe was recorded was additional deputy director, lordship, additional director. As per the notification, lordship, he has given power of the commissioner.
So this ground was taken in other petition also.
আমার দোকানের গ্রাউন্ডে নহয় বুঝিও না
Notification আছে।
কি বলবি আমি কোন আমার গ্রাউন্ডে নহয় এইটো আমাক জনোৱা নাই সেইটোহে লাগে আমাক ৰেকৰ্ডত দি থাকে থাকক ভুল কি লাগে
Arrest memo was given to him, ground for arrest was supplied to him.
কি হৈ গেল
Lordship, with respect to the,
ফ্যামিলি মেম্বার নহয়
I want to place that Radhika judgment, paragraph.
ফ্যামিলি নাই my lord, but only one thing, my lord. Then grounds of arrest are there, my lord, sorry, reasons to believe are there. Dispute is not on that, my lord. Whether as per directive of the apex court, as is contained in this 25 authority, my lord, para 32, my lord, whether it has been communicated to me. It is their denial that it is their private document. Have I made my position clear? Answer is neither only that much, my lord. That grounds of reasons to believe are there in record. There is no dispute on that. Maybe there, may not be. I am not bothered, my lord. Only it is to be communicated to me. Have I made my position clear, my lord? Or regarding that, my lord, they have denied it, that they have not communicated on their own affidavit. On that count, I deserve benefit. 41A, it cannot be nullified as per this authority, my lord. And my lord, PIN number is missing in 3 vital documents, my lord. Page 20, it has not been communicated, the letter to family members, my lord, page 20. That is as regards section 48, my lord. Violation of 48, and that is apparent in the latest authority, my lord. Then page 49. Authorization to arrest, DIN number is missing, letter creation, as per us. Page 51, grounds of arrest, it is missing, my lord. As per their circular, it has not, my lord, page 20, 49, and 51. DIN numbers are missing, my lord. And the circular is still a good administrative order, my lord. It has not been nullified by any court, my lord. And my lord, my lord, another paragraph that is academic, my lord. Otherwise, my lord, it will go haywire. The department can withhold certain materials regarding that reasons to believe are to be communicated to me. This is the law. Nobody can deny it, my lord. It has not been communicated. Now, what the department can withhold, it is there in this authority. I did not read it because this is not the subject matter. They can, my lord, by black lines, they can erase something. But they are not the judge. They have to place it before the court. Have I made my position clear? Communication is a must, my lord. This authority has not, should I read it? I should not read it again. But saying something, it will be, my lord, otherwise, everything will go haywire. Para 42 of this authority, my lord, Radhika. This is not the ratio. This is the ratio, but not so far as the subject matter of this case is concerned. Our case is, it may be there on record, it may not be there on record. If it is there on record, that will not do. It is to be communicated to the arrestee. Reason to believe. Am I clear, my lord? Let me read 2 lines that paragraph, my lord. That is the law. This authority itself, my lord. How can they read one? It cannot happen, my lord. Para 32, my lord. With all respect, my lord. The contention of the DOE that the grounds of arrest were mandatorily required to be supplied to the arrestee. Reasons to believe, being an internal and confidential document, need not be disclosed. The plea of the department, my lord, either in customs or in, my lord, GST, was decisively rejected in Arvind Kejriwal. Have I made my position clear? When decisively rejected, meaning thereby, the law is this, that it is to be communicated to the arrestee. And if it is not, if it is there on record, what they can do, this is not necessary for this case, but for logical reasons, academic reasons, let me read para 42. That is the end of the matter, my lord. I'm taking a minute, my lord. Para 42. Para 42, my lord. What by black lines, reasons to believe they can, my lord, blacken something, my lord. But 42 is clear, my lord. We would accept that a one-off case, it may not be feasible to reveal all materials, including names of witnesses and details of documents. Here, nothing has been disclosed to us. Have I made my position clear, my lord? Not to talk about these, my lord, items. When the investigation is in progress, this will not be the position in most cases. In rare cases, it may happen. DOE may claim redaction and exclusion of specific particulars and details. May claim. They are not the judge, my lord. However, the onus to justify redaction, meaning thereby removal of some part, would be on the DOE. The officers of the DOE are the authors of the reasons to believe and can use appropriate wordings with details of materials as are necessary in a particular case, as there may only be a small number of cases where redaction is justified, meaning thereby removal of some parts, my lord, is justified for good cause. This reason is not a good ground to deny the accused access to a copy of the reasons to believe. What more is needed? In most cases, have I made my position clear? Thereafter, where the non-disclosure of the reasons to believe with redaction is justified and claimed by the department, they have to claim it. The court must be informed. Have they informed your lordships? No. Am I correct? Inform. The file, including the documents, must be produced before the court if they claim redaction, my lord. Here, no redaction has been claimed. Have I made my position clear? One part is good, one part is bad. Kindly read. Let me read the 2 lines more. Thereupon, the court would examine the request. If they find justification, a portion of the reasons to believe and the documents may be withheld. That means reasons to believe are to be provided to the arrestee. Some part may be withheld with permission of the court. And the parting line is, my lord, it's a nail in their coffin, my lord. This regards consideration and decision by the court, respected court. DOE is not the sole judge. Have I made my position clear? It has not been communicated on that count also. Reading the entire judgment, yes, my lord. That's a different matter. But this is the law in India.
Yes, you can submit.
Page 20.
Page 20 of
Of the bail application. So DIN number was not mentioned, it is mentioned in the top by hand.
20.
Yes, sir. And it is not my document, it is document annexed by the petitioner law.
What is it?
Yes, it is there. Yeah.
What is it? Huh? What?
I think top.
Top.
Oh, oh. My lord, kindly see. Yes, yes. By handwritten, we missed it, my lord. In handwritten form, it is there. One part is, my lord, typed out, and one part is handwritten. A question mark, that may be my submission, my lord. Why the entire document is typed out, and one part is, my lord, written by longhand? Or the beauty of the department, they can do anything.
It was certified by the learned CGM also.
No, certification is immaterial. Certified, whatever has been, what was there on record.
And it is
But it is, my lord, kindly, they are after me. My lord, it is in black and white. It is not typed form. But the other 2 documents, my lord, let him point out. I may be wrong. He may correct me. Raise 2 pages, my lord.
What is not there, lordship, I will not make my submission. That it is there. When it is not there, it is not there. But in page 20, it is there. And with regard to.
My lord, I have never argued that it is not there. He has pointed out, I have said yes. But I have said the only difference is it is in longhand.
If it is there, lordship, I am not disputing everything. What is available on the record, that is available on the record. And reason to believe, lordship, I have placed before lordship. And it is not mandate that it should be provided. If they demands, lordship, definitely in other cases, when the petitioner demanded, the court had directed, we supplied the photocopy to the petitioner's lord. Now, lordship, with regard to objection made by the one of the judges up to page paragraph 78.
In Radhika.
In Radhika. Paragraph 9.
Huh?
Paragraph 9. Of,
Whichever is not the majority, my lord, the ratio would go only.
no, this is not minority judgment, Lordship.
No, no, I'm not saying that.
It is addition.
No, I'm not saying that. এই কথা নপঢ়িব লগাতে এটা উলিয়াই দিব পঢ়ি থাকিব এনে মানুহে শুনি থাকিব কথা হ'ল নেকি
It is by Justice Vellayan Trivedi. Okay, paragraph 1. While completely agreeing with the well-considered opinion accepted by the Honorable Chief Justice on when how the proper arrest should be exercised by the authorized, I have thought it expedient to pen down my view on the jurisdictionary power of judicial review under Article 32. Paragraph, Lordship may come to directly paragraph 9. Married Lordship. However, when legality of such arrest made under special act like PMLA, UPAPA, Foreign Exchange, Custom, GST Act, etc. is challenged, the court should be extremely locked in exercising its power of judicial review. In such cases, the exercise of power should be confined only to see whether the statutory and constitutional safeguard are properly complied with or not. Namely, the ascertain whether the officer was an authorized officer under the act, whether the reason to believe that the person was guilty of the offense under the act was based on materials in possession of the authorized officer or not, and whether the arrestee was informed about the ground of arrest as soon as maybe after the arrest was made. Sufficiency or adequacy of material on basis of which the belief is formed by the officer, or the correctness of the facts on the basis of which such belief is formed of arrest the person would not be matter of judicial review.
My lord, we
Yes,
have
Lordship.
only seeking bail, my lord. We are not saying that the arrest is, my
And
lord,
Lordship,
bad in law, my lord. We have not
Now,
come on.
there are two things, Mr. Kyle. Question is that they're not challenging the arrest. Arrest
that
was
is correct.
under due procedure of law. And obviously you have shown in your record also, there are reasons to believe has already been recorded by the officer.
Lordship.
The only question they have been, this the challenge is that whether those reasons to believe these things are whether communicated to the
That was not
the
communicated.
arrested. That is the issue. And number 20, you have already pointed out that there are DIN number is there. 2-3 documents, the DIN numbers are not available.
Yes, in two documents.
And the arrest memo 47, 48, 41A is not complied with. These are the issues.
In my humble submission, 41 is complied because section 70 is parameter with the section provision of 41. So it was complied, and Supreme Court has fortified this argument in paragraph 69 of the Radhika judgment. And Lordship, with regard to another submission was made that is a blind. Lordship, page 158, paragraph 15 of my affidavit was. Paragraph 15, page 158.
Of your.
My affidavit. was.
No, it is not yours. I can have to confirm.
Affidavit was called for. Lordship, it is
No, no,
in
yes.
the record.
It is, yeah, you follow the head on, huh? I did follow for us. Page, what is the page?
158.
এখানে নাকি?
Page 14. Absolutely. Mr. Order.
This one is. No, this one. Yes, it is. Yes. 158, na?
158, paragraph 15. Married laws.
Yes.
The respondent to state that the further custody of the petition is essential in the instant case. If the petition is allowed on bail, the investigation of the case will hamper and will it create
Mr.
prejudice
Order to
on the part of the respondent. Next, paragraph 16. That the respondent beg to state that all the documents relied upon by the petitioner regarding 100% vision disability does not appear to be true, as the petitioner has himself admitted that he operates
30.
two mobile phone and is indulging
31.
issuance of fake invoices,
Aru, 36,
which directly
Is
contradict
36,
his
no?
claim of blindness. The respondent
Schema.
further praised this honorable
That
court
is good, but
to
get
give
order.
a direction to the constitute a medical board to examine the genuineness of the medical certificate annexed for the petitioner. Then paragraph 17, that the respondent submit that during the production of the petitioner was fully cooperating before the magistrate, and no such instance of 100% vision disability was evident during the period. That the respondent further begged to submit that during the custodial interrogation, the petitioner was fully cooperating with the IO of the instant case, and as such, there is a doubt regarding his vision disability. And Lordship may please to see the two documents filed by the petitioner along with the bail application. Lordship, page 14. He put his signature along with dates.
Braille, my lord. One can write. Blind man can write. There is no bar.
Below. Then page.
Now you're saying it is under braille.
No, I'm not saying that, my lord. Blind man can put signature, my lord. Reading?
No, under braille, he is not putting this one.
No, I'm not saying under braille, my lord. This is between you and me. What I'm saying, my lord, blind men can put signatures, my lord. There is no bar to it, my lord.
Page 14, page 15.
There is thought, my lord.
And
And he was not blind by, I mean.
Oh, that I do not
by,
know, my lord.
by birth, he was not visually impaired presently or what?
That I do not know, my lord. From whether from childbirth
Because
he is
there are,
blind.
yeah, there are
That I do
differences
not.
because
That I
if
do
the
not.
person is
Then we are
supposed to
lying, my lord.
subsequently they've developed
Maybe,
this
maybe.
issue, then he can put his signature.
Yes, yes.
Or that is the issue.
During application because.
My lord, it is there in the certificate. itself.
That is the certificate is under challenge by him, then it may not
Let
be
him
genuine.
challenge it, my lord. Yeah, let him go. Let him go to jail, my lord. He is a case of blindness. The diagnosis in this case is retinoplegma both eyes. Something, my lord.
Subsequent.
I don't know, my lord. Where? Page 36, my lord.
Certificate is dated 1/11/2023.
Ah. No. Huh?
1/11/2023.
No. He has 100%. My lord, kindly, my lord, he is a case of blindness. Whether, my lord, from birth, I do not know, my lord. The diagnosis is retinitis pigmentation both eyes. This is, my lord. Maybe, I don't know, my lord. Blind is sure. No two ways about it. My lord, putting signature.
Retina may subsequently damage also. That's just the retina putty is there. Probably it's subsequent damage.
I also cannot say because while during interrogation he cooperated and he put his signature. He's operating two mobiles. If he's 100% blind, then how could he operate all these mobile phones and others? That is our contention.
His cooperation, that itself is a ground of bail, my lord. Otherwise. Blindness, my lord, that was never raised before the.
Have you seen one I have seen in it was in the television. It was
Netflix, my lord.
no, not in Netflix. Not that I'm not in that manner. It's a one person from this railway station. I think he was a blind person, but he was involved in sending the girls to the 371, 372, this kind of.
370 IPC, my lord.
He was there. He
Oh, yes. Assam, my
operating
lord.
all the in Assam.
Assam.
But otherwise, he is a very he's a blind person.
Yeah, man.
So blind person can.
Let's see if I'm relying on two authorities of Honorable Supreme Court. One is 2011-14 SEC page 7737.
Yes, two authorities are there.
Yes. In one case, noted that Deepak Subhash Chandra Mehta, the bail was seek on the ground of disability and medical ground. Honorable Supreme Court rejected paragraph 3. I am directly come to paragraph 5.
Which one? Paragraph 3?
Paragraph 5.
No, your judgment.
The judgment is 2011-14 SEC page 737. One page judgment.
Oh, yes.
In view of the fact that the other two accused, namely accused A and 2, were released mainly on the ground of illness and old age, and the assurance given by the London Additional Solicitor General that trial will be completed within period of 3 months, we are not inclined to accede to the request of the petitioner. However, we make it clear that for the reasons of the trial continued beyond the period assured by the London Additional Solicitor General, the petitioner is free to move the bail application before the special court. In such event, the special court is permitted to consider in accordance with law. We also direct the special court to make endeavor, Lordship, paragraph 3, I'm sorry. On the other hand, Mr. P.P. Mehta, learned additional Solicitor General, after taking us through the serious allegations and charges submitted, that the case of the present petitioner cannot be compared with other accused who were ordered to be released on the ground of medical illness. He also submitted that trial will be completed within a period of 3 months. According to him, considering the gravity of the allegations made, the present petitioner is not entitled to bail. So bail was not granted. In another judgment, Lordship, Honorable Meghalaya High Court, although this is a case of NDPS, where the accused was granted bail on the ground of HIV because she was suffering from HIV. Supreme Court negated that cannot be ground. Paragraph 5 to reflect.
HIV was rejected because he had number of cases, my lord. On that counts Meghalaya NDPS, that was rejected by the apex court. And first case has no bearing, my lord.
Because it was rejected on the, he seek the bail on the ground of medical illness.
Exactly, entire judgment you read that case I know, my lord. Meghalaya case went to apex court.
Yes.
Apex court rejected because in my lord NDPS cases, if he has multiplicity, he or she has multiplicity of cases, my lord, then it is to be considered in a different light, even with existence of high degree of sicknesses. My lord.
He was granted bail by the Meghalaya
Cancel
Court on the
some.
ground of HIV
Yes,
because
yes,
he was
yes.
suffering from HIV. That was negative. Lordship, now page 156, because it is a white crime, white color crime.
But 60-day period offense, my lord.
Yes, it is correct. Look.
White color, but 60-day period.
They are admitting that is also.
But say, no, whatever you say, I'll have to agree.
Paragraph 1, page 156, paragraph 2. In my affidavit law.
Yes, yes, that's what I have put. Ako panalo po. Paragraph 156.
Page 156.
Page 156.
I quoted the paragraph 1 of judgment that I want to read. In the judgment passed by the Honorable Supreme Court in
Jagan Mohan read this case.
paragraph 15. Economic offense constitutes a class apart and need to be visited with different approach in the matter of bail. The economic offense have deep-rooted conspiracy and involving huge loss of public fund need to be viewed seriously and considered as grave offense affecting the economy of the country as a whole and thereby posing serious threat to the financial health of the country. Paragraph 16. While granting bail, the court has to keep in mind the nature of accusation, the nature of evidence in support thereof, the severity of the punishment which conviction will entail, the character of the accused, the circumstances which are peculiar to the accused, reasonable possibility of securing presence of the accused at the trial, reasonable chance. Lordship, here I want to mention that another case is registered against the present petitioner and someone has been issued to him.
One other case.
Yes, against the Sugam General. And in that case, what if assessment has been made and he has been issued someone to that effect. I'll produce that. That is available in the file also. And petitioner number 2 is a companies of the petitioner number item number 1.
Second to defalcation basic maybe.
Same.
Basic maybe no.
Same.
First to form है second to basic.
हाँ एक ही मने अभी दूसरा एक ही लोग ऐसा है.
Amount to basic.
Amount to file को
Basic I get to.
So Lordship, considering the stage of investigation, if the accused is enlarged on bail, it will affect the entire investigation. And as per section 132, we can detain him for maximum period of 60 days. And we hope that we will be able to file our final complaint within this period of 60 days. This is my motion.
Someone does not mean arrest. That again, my lord, that thing has to be there, my lord. Reason to believe, my lord. With all respect, my lord.
This time they may punish.
No, I'm not saying that, my lord. Reason to believe has to be formed. If it is within their domain, they may arrest, they may not arrest.
Ah, yes. That is there.
সেখানে পুলিশে মই arrest হলো দুটা কেস আছে এইটো না না correct I agree মানে NDPS নিচিনা নহয়
No, no, NDPS is.
my lord, we have taken a lot of time, my lord. We would have taken it.
The other matters will be
Sorry,
adjourned now. Really. I think, এইটো দিব পাৰো যদিটো কালি বোলে উলিয়াই দিম
Compatible নাকি?
ডেলিভাৰী অলৰেডি মানে
Compatible, no? What's that? My lord, all offences are compatible also.
Yes, it is there. It is. Supreme Court has also
So
taken-
exception, my lord. And Supreme Court has said that in not in so many words, I should not read it. Same authority.
It is there, Lord. Even Radhika Supreme Court
Radhika.
mentioned that when it is compoundable, that is not resolved. The accused from.
He understands his own lines, my lord. In one court, it is on record that this authority is against, my lord, this thing, applicability of his jurisdiction. তাতে তোমার নাম তো লেখা আছে। But that is my lord, with all respect, my lord. There is nowhere in the judgment. Let that matter come up, my lord, we will argue there as regards that case. That is his understanding of law.
That has been overruled by this judgment.
Hey, overall question, that has, what will face it? You are wrong.
Yet, in so many words, Supreme Court says that all the authorities, because earlier, Lordship anticipatory bail was not.
হব এটা নাই গোটেই পঢ়ি শেষ হৈ গ'ল তুমি ভুল কথা কৈছা nothing has been
Yet, this is mentioned.
whatever give line করে বুলি কোনটো কৈছে এইটো সরি এটা কথা পিছত কথা এই কোনটো
Much obliged.
obligement
Yes. যিকোনো এটা মাতিব পাৰিব যিটো ফাৰ্ষ্টত আহে
45.
We don't know. Consider any prayer of any person, any advocate to accommodate the dates. I mean, all will be after left of and days to be placed because otherwise it will get very problematic.
My lord, in this case, it is arrested on 12/1/2025. In this case also no notice given, but however, I am not mentioned in my petition. Now today is 81 days. The lawsuit can receive the FIR that section 4 will not applicable in my case, my lord. I am not a person concerned, my lord. Person concerned is another accused person who was also arrested. The lawsuit can receive page 9.
Page 9.
9 is the FIR.
Have you taken steps? Are there?
But it is motion. The first time come it is.
Oh, acha, motion column.
Because only I mentioned it before. This petitioner, his from today, his examination is going on. Semester examination, sir. Yes, second semester examination.
What is his name?
His name is my lord. Priyanshu Kolita. The lawsuit can list the FIR. FIR, the main accused person is my lord. Ujjal Nath. He is the main accused person. The lawsuit can list the FIR. What allegation is that victim on his telephone call came to my house. And in my house, that the accused number 1 has committed sexual intercourse with her. This is the case. I have been falsely implicated in this case, my lord. So 82 days I am now behind the bar. My exam is going on from today, my lord. Session semester examination, my lord. And it is end on, my lord, 10. This examination continue on 10, my lord, 10/4. So, my lord, if I am will be allowed to go on bail, then I will participate in remaining examination, my lord. Today already done, my lord. This is the examination. But FOCSO is not available in my case, my lord. FOCSO 4 is not available in my case.
What is that?
82 days, my lord. Only by considering so that we can appear in the examination.
He was arrested on?
12/1/2025. 12/1/2025. So 82 days today, my lord.
And notice is also not arrest. Notice under section 47 not served on me, my lord also.
They have not annexed this week. These are not before us, yes.
Lordship, 61 is there, 61 2. 61 2 is there, Lordship.
What, 61 2?
That is conspiracy.
Conspiracy.
Conspiracy is there.
This is there, my lord. That is why I am 81
And
days,
in her
82 days I am
house,
jail.
In that house, the occurrence took place, Lordship. So it, without looking into the city, it cannot be stated that she has no role, Lordship.
No. It is rule, my lord. FIR is clear. FIR is clear that the victim has love affairs with the accused
Not
number
only
1.
the incident took place on that occurrence was in house of the accused number 2.
Petitioner number 2, my lord. This is
But,
the
but he also secretly recorded the entire incident in camera
yes.
and he threatened the girl that it will make viral. So this is the role played by this person.
Played by him. That is why 82 days today he is in jail. my lord.
Otherwise, apart from going to any other aspects, 82 days he is behind the bar.
My lord.
That matter only can be considered and
Yes,
he
yes,
is
yes.
appearing, what appearing he is?
Session semester examination. BA
GTC.
second semester session examination. my lord. I
Maybe
give the I give the
commencing
program,
from which time?
my lord,
Commencing from when?
from today.
So he missed the case.
Today I cannot appear, but remaining I will appear. Ma'am. It is coming up to 10, my lord, 10-4. Today I will miss, my lord.
That
It
is
will
the
be at
only
back,
part.
my lord.
Otherwise, 82 days in custody, that is. Heard Mr. J. Ahmed, the learned counsel for the petitioner. And also heard Mr. K. Gedas, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Ahmed that the present petitioner is in custody since last 82 days. And
81 days.
so 81 days, and he is not involved in the alleged offense, and no case under POCSO is attracted against him. However, he admits that the incident had taken place as per he admits as per allegation. The accused number 1 had a sexual intercourse with the victim in his house, and that apart, there is no other allegation against the present petitioner. Further, he submitted that the accused petitioner is pursuing his degree course and his
TDC
TDC second
semester
year
session examination.
second year sessions examination has already commenced from today, and to appear him in the examination also, his bail prayer may be considered. However, he is still ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of bail. Next, Mr. Das, the learned edition people submitted in this regard that the case is also registered under section 61, subsection 2 of the NSS, and the present petitioner is also involved in the conspiracy as revealed from the FI itself. However, he submits that the length of detention may be considered. Next, considering this submission made by the learned counsel for both sides, without going into the detail of the merit of the without going into the detail of the merit of the case, and only considering the length of detention, I find that the IO got sufficient time for his custody interrogation accordingly. Interrogation preserve and also considering the fact that the petitioner is appearing his TDC secondary examination.
Second semester session examination.
Whatever is examination, and I find it a fit case to extend the privilege of bail to the present accused petitioner with a direction to cooperate the IO in further investigation. To whose satisfaction this one is?
Special session judge POCSO Huzai.
Special
Session judge POCSO
Special
Huzai.
judge POCSO Huzai to the satisfaction.
High level.
So timing also influence. Alright, I'm at one. 1 4. What?
14 timing.
What was timing?
If you do that's to the construction. Only maybe Mr. Martin is a business and I.
Oh, acha. Yes, you are appearing as a Michael. No petition, so he is the petitioner, sir. Huh?
Item number 25.
No other matters will be taken up, this one only.
Lordship, it is always instruction. part
Only
had-
to attack instruction.
Instruction, Lordship. PP has
Okay, we'll see to it.
observed instruction.
Petitioner side is not there. Fourteen is not there. no? Petitioner says, remain absent on call. When can we fix? After, least after 1 week. Twenty. This is-
25.
Yes, Sharma, what was the, yes,
Lordship,
charge is submitted.
Lordship, one small submission, Lordship. Already 57 days behind the bar, Lordship. So, Sasi submission means the investigation is already over. So what is the requirement of personal interrogation, Lordship? 57 already days behind the bar. So I will be allowed to go on, but I will provide the investigation, Lordship.
No, cooperation will not required now. Your cooperation will be not
In
required.
this regard, Lordship, I want to submit one order, Lordship. It is passed by Honorable Mr. Arvind Puppan, Lordship. After submission of charge sheet, Lordship, bail was granted, Lordship. Kindly
Yes,
peruse that order, Lordship. Kindly peruse
what
that
you want
order.
to say?
Otherwise, charge sheet submitted, Lordship, and he need to appear before the trial court.
Kindly peruse the order, Lordship. That was passed.
Part Mr. 25. Part Mr. A. Sharma, the learned counsel for the petition. And also part Mr. K. Das, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Case was. But you have received a CD also.
That was the wrong one. I have said it wrong.
Oh, acha, acha. Is submitted by Mr. Das that the case has already been charged sheeted. Height case number.
Oblique 25, dated 31/03/25.
25. Accordingly, he submitted that the petitioner may prefer an application before a application for bail before the learned trial court below. Mr. Sharma submit next para. Mr. Sharma submitted in this regard that accused petitioner is behind the bar since last 57 days. And as the case has and 57 days and does he 57 days he did submitted that he is 57 days and hence considering his period of detention he may be released on bail. He further submitted that that the accused petitioner being a local resident, permanent resident of his address locality, he will appear before the learned trial court below as and when the date is fixed for. But when where are you going to submit the bail bond? Before the learned trial court? It is, as and when the case is fixed for. As and when the case is date is fixed by the court, Latin court. Considering the entire submission made by learned counsel for both sides. And the period of detention already undergone by the accused petition. vis-a-vis the gravity of the offense. I find that it is a fit case to extend the privilege of claim to the present accused petitioner. To the satisfaction of, it is a special judge, no?
Special, oh, sorry.
Where POXO, which court? It is under which? Kamrup, Kampur.
Kampur PS.
Kampur is
Noga.
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 Special judge Noga. To the satisfaction of special Noga or Hojai Noga?
Noga.
Aro bhai, timing আছে নাকি? Timing, no. Now see, we are not in a position to fix any date now. So all matters will be left over. Then the registry will accordingly fix it. Even if it may be 675 also, we are not in a that. Like everything will be, it will be left over now.
There is an interim order, item number 33, 34.
31 also, madam, there will be
Interim order.
Interim 31.
Yes.
31 to Rokham, interim be extended for next of listing, and your is 32.
I get 33, 34.
But 35, madam.
No, your one interim is a
33, 34, there is an interim order.
33, 34 interim.
Yes.
34, 34 interim be extended till next date of listing. 35 also interim be extended till next date of listing, and 31. 31, 33, 34 and 35. Okay. It will be fixed. Okay, then we will liquidate this.
Current है तो एक नए देरी में से आ रहा है ना आप लोग भी वन से keep on extending don't you think we keep on 5 all these matters na 5 is like na hello 31 33 hello 31 33 35 Aru, back of left out also. Lights off. Thank you.